Good morning. I call this meeting to order. I have a letter from the governor, which reads, Dear Councilors, I'm pleased to nominate Kristin Michaud to the position of Associate Justice of the Juvenile Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. Sincerely, Maura T. Healy. Do you have a copy of this letter?
I don't.
I'm going to make sure you get a copy.
Thanks so much.
Here you go. Good morning. Would you like to introduce the folks you brought with you today?
Well, that's gonna take 2 hours.
Just go. Take all the time you need. This is your day.
Glennon, a friend. This is Attorney Judy Glennon, and also a friend. Attorney Judy Glennon, who's one of my witnesses. Attorney Stephanie Lyons, a friend. Joelle Flynn, a friend. Sarah Fallon, a friend. Also the first Assistant Clerk Magistrate of the Somerville District Court. Judge Kimberly Foster, Associate Justice of the Chelsea District Court. She's also a witness. My kids, Abby and Jack. My friends, Mike Drago and Chris Vitale. Judge Carrie Ahern, the first Justice of the Essex Juvenile Court. And then Judge Dana Gershengorn from she's the Chief Justice of the Juvenile Court.
Very good. Thank you. Let's call your first witness.
All right, I would like to call Judge Kimberly Foster.
Hi, good morning, everyone, and thank you for having me here today. It's my absolute pleasure to be here to testify in support of Kristin Michaud in her nomination to the Juvenile Court bench. My name is Kimberly Foster, and I am an Associate Justice of the District Court. I've known Kristin for almost 25 years and can assure you that she has the requisite experience, temperament, and work ethic to make an excellent juvenile court judge. I first met Kristin when I became an assistant district attorney in Middlesex County in 2001. I was assigned to the Cambridge District Court team, and she was one of our victim witness advocates. I believe that I learned the most about domestic violence cases and the complex challenges and struggles those victims face from her. She was fearless in her role and truly allowed victims to feel safe and find their voice. Kristin left a huge void when she left the DA's office to pursue her law degree, but we were all confident that we would see her join the office again as an ADA, which she did. Kristin loves the juvenile court. I believe it was her time as an ADA in the juvenile court that sparked her love for it and the issues and the people it serves. Professionally, in the juvenile court, she's had the experience in that role as an ADA, as well as in her private practice, with a significant focus being her work in the juvenile court, where she competently and compassionately handled both delinquency and civil work of the juvenile court. Most recently, I had the pleasure of working alongside Attorney Michaud again when I hired her as an assistant clerk magistrate in the Somerville District Court in 2021. Kristin hit the ground running and was one of the best decisions I made during my time as the clerk in Somerville. As an assistant clerk, Kristin is a hardworking team player who is a lover of learning. She always exercises the wide discretion she holds in that position intelligently, carefully, thoughtfully, and with full consideration of both parties. She has learned how to wisely exercise discretion, and as a judge, she will already be able to delicately temper public and victim safety with the sometimes, most oftentimes, very complex needs of those the court serves. Attorney Michaud has proven herself to be an integral part of the smooth, efficient, and successful daily court business of a busy district court. She has mastered the courtroom, and every session run by her runs smoothly without issue. Her position as an assistant clerk in the Somerville District Court has allowed her to hone the skills that will translate well to the bench. I have no doubt she will positively contribute to any juvenile court she sits in. The juvenile court will no doubt benefit from Kristin's administrative experience in the district court. She is already intimately aware of trial court rules and policies and perfectly understands the roles and the responsibilities of every person who works in the courtroom and throughout the entire courthouse. She has the demonstrated ability to work as a team, always fostering the focus on our shared goal of providing justice with dignity and speed. If confirmed, I know that Kristin will hit the ground running. She is organized and always prepared. She is constantly availing herself of any opportunity to learn and always stays up to date on the ever-changing legal landscape. Personally, Kristin is an amazing mom to two wonderful kids and a friend to many. She leads by example and inspires others to join in support. She is so involved in her community and all the extracurriculars that her children participate in. And as a fellow working mom of two, it has always impressed me just how much she does to support her children's school or their sports teams and volunteering in her community. Kristin is kind, she's thoughtful and compassionate, and she has the temperament and the scholarship that is necessary to be a great judge. I'm confident that she will make a seamless transition to the bench and will be a great addition to the juvenile court if confirmed. She will most certainly be a great colleague to all those other judges sitting in the juvenile court. So I believe that all great judges have a few things in common. First, collegiality. They need to have the ability to be a good colleague, to be a team player, always willing to cover or help and provide support for each other, or be a sounding board on decisions or crazy situations that are bound to come up on a daily basis. The job is hard enough and isolating enough. You need to be a good teammate. Second, you need to have the desire and the commitment to be a lifelong learner, to stay consistently educated and updated on both the law and how it intersects with mental health, substance abuse, and brain development, and best practices which evolve and are ever-changing. And third, temperament. You should have compassion for people and empathy for the conditions that they're in, and an ability to treat each person that appears before you with kindness and respect. Kristin has demonstrated that she already has and practices those qualities, and I know she will hold them even closer if given the opportunity to bring those skills to the juvenile court bench. They will be lucky to have them join her team. They will be lucky to have her join their team. What a great nomination the governor has made. Kristin, congrats on getting to this point. All of your hard work and dedication is paying off, and I am so proud of you and happy for you and your family. And I'm happy to answer any questions that any of you might have.
Thank you. Does anyone have any questions for the witness?
I get to go
Stop
first.
it. Thank you.
Thank you so much. And Attorney Judy Glennon?
Good morning. My name is Judy Glennon. I appreciate the opportunity to speak to the council in support of Attorney Kristin Michaud's nomination to the judicial bench. I was fortunate enough to meet Kristin 15 years ago when I was serving as an attorney on the Children and Family Law panel, and continue that friendship to this day as an attorney for the Department of Children and Families. Our first case together placed us on opposite sides. I was immediately impressed with her knowledge of the law, her professionalism, and her dedication to her client. But what impressed me the most was her genuine empathy and respect for not only her client, but the entire family dynamics. In a case that at times felt hopeless, Kristin approached it with compassion and clarity, resulting in successful outcome for her client. In that moment, I recognized that despite being a few years younger, she possessed a level of skill, insight, and emotional intelligence that I deeply admired. She quickly became more than just a colleague, but also a trusted resource. Myself and others sought out her guidance from her experience as an assistant district attorney and a domestic violence advocate. She earned the respect of her peers and the trust of the Committee for Public Counsel Services, which repeatedly called upon her to train panel attorneys, mentor new lawyers, and help guide the next generation of advocates. For over a decade, Kristin worked on a wide variety of cases, each which have helped shape the thoughtful, well-rounded approach she'll bring to the bench. Kristin's kindness and understanding isn't limited to her role as an attorney or a clerk. It's just who she is. She's deeply devoted to her family. She has managed her children's sporting teams, always making sure that every child on the team has the same experiences and opportunities. My daughter, who was sworn into the bar in 2024, has regularly sought out Kristin's guidance from pursuing relationships to navigating the early demands of practice and professional life. And I'm truly grateful that she has Kristin as a role model. In the juvenile court, you are seeing people with very different life experiences and at their most vulnerable times. Kristin understands the impact her decisions will have on families and has consistently demonstrated that she has the temperament and the knowledge which is essential for a judge in the juvenile. Again, thank you for the opportunity to speak before the council, and I have no doubt that Attorney Michaud will serve with distinction and be a valuable asset to the bench.
Thank you so much. Is there anyone who has questions for the witness? No. Thank you so much. Is there anyone here who would like to speak in opposition to the nomination? Hearing none, we would like to hear from you.
Thank you so much. Good morning. Thank you, Governor Healy and Lieutenant Governor Driscoll for this nomination, and to Chief Counsel Jesse Boudou and Deputy Legal Counsel Derek Kesselheim for their guidance through this process. Thank you to the members of the JNC, Kimberly Baptiste and Sonia Altamirano for their seamless communication, and to the governor's counselors for having me here today and hosting calls and meetings prior to today to consider my nomination. I want to also recognize and thank Judge Tan and Judge Ahern for encouraging me to apply and supporting me through this process. To my witnesses, Judge Kimberly Foster and Attorney Judy Glennon, for your thoughtful and kind words, and to everyone here today in support. To my kids, Abby and Jack, you are the most important people in my life and have provided the best job ever for me watching you grow into awesome humans. To my husband and best friend, John, thank you for your support and love. Finally, to my parents who couldn't be here due to a recent surgery, but are watching through the live stream from New York, thank you for your unconditional love and continued support. Much of who I am and how I approach both my life and my work come from my parents and the example that they set. Both model an unwavering work ethic and a deep commitment to their community. My dad, who was raised in Brooklyn, New York, spent 38 years in law enforcement, ultimately retiring as an inspector after steadily rising through the ranks. At the same time, he was and still is a volunteer firefighter, now in his 64th year. Growing up, I watched him leave our dinner table, holidays, and family time at a moment's notice to respond to fire calls. Sometimes, if no one was around to watch me, I had to go with him on calls, which meant sitting in the car or watching from a distance. He continues to inspire me with his discipline, bravery, and humility. My mom, originally from Scranton, Pennsylvania, worked 44 years as a legal secretary in New York City. She is also deeply committed to helping others through her work on this day with the fire department, Ladies Auxiliary, now in her 55th year, and shorter endeavors such as her volunteer efforts after September 11th. She also served as the family anchor, quietly providing constant care to our family, especially her disabled brother, my Uncle John. From her, I learned empathy, patience, and the importance of treating every person with dignity. She often said, "You never know," a reminder not to judge others without understanding what they may be going through. Those simple 3 words stayed with me and continue to guide how I approach people, especially in difficult circumstances. My parents worked hard. I cannot think of a time when either one of them called in sick. Public service was never something they told me I had to pursue. It was just simply the environment I was raised in. After college, I served as an AmeriCorps Vista, which ultimately brought me to Massachusetts. In 1999, I began my career in the Massachusetts court system as a victim witness advocate, where I worked closely with victims navigating the criminal justice system. That experience shaped my understanding of how critical it is for people to feel heard, informed, and supported. I went on to attend law school at Northeastern, where I had the opportunity through co-ops to work in a variety of legal settings, including clerking for Boston juvenile court judges, working in the family law unit at Greater Boston Legal Services, and as a 303 prosecutor. After graduating, I became an assistant district attorney, which included a year in the Lowell Juvenile Court. Even within the constraints of that role, I sought to understand the broader circumstances behind each case and opportunities to balance accountability with rehabilitation. In 2009, I started my solo law practice, which led me to spend the next 12 years representing children and families in the juvenile court system. I represented a wide range of clients, children, parents, and extended family members in complex and emotionally charged cases. I met clients in foster homes, schools, detention facilities, and group homes. I saw firsthand how trauma, instability, and lack of resources shape people's lives. My role was not only to advocate, but to patiently listen, to advise and explain, and to ensure my clients' voices were heard in a system that can often be frustrating and feel overwhelming. I also mentored newer attorneys on the Children and Family Law panel and served as a guardian ad litem, which deepened my ability to evaluate complex circumstances and make recommendations in the best interests of children. Currently, as an assistant clerk magistrate in the Somerville District Court, I serve in a neutral capacity, applying facts to the law and assessing credibility while presiding over matters such as probable cause hearings and small claims trials. I regularly assist members of the public, many of whom are self-represented, in understanding and navigating the legal process. I pride myself in being patient, compassionate, and thoughtful. This role has strengthened my ability to remain impartial, make sound decisions under pressure, and ensure that every person who comes before the court is treated with fairness and respect. Outside of the courtroom, I remain committed to my community. I volunteer as a team manager for 2 youth soccer teams and serve on the board of a girls' softball league. In these roles, I work to ensure that all children have access to the same opportunities. It's important to me that every child feels included, supported, and valued, principles that mirror how I approach my professional life. Throughout my career, I have consistently worked with individuals facing trauma, instability, and crisis. I've made it a priority to educate myself on trauma-informed practices and bias. If confirmed, I will treat every person who comes before me with respect and dignity, and I will continue to reflect on and learn from the decisions that I make. Above all, I'll approach this role with the understanding that every case represents real people with real consequences, and commitment to administer justice fairly, thoughtfully, and with integrity. My mother's words, "You never know," continue to guide me. They remind me each day to resist assumptions and avoid rushing to judgment, disciplines that are essential to being a fair and thoughtful judge. Thank you for your consideration, and I welcome any questions that you may have.
Thank you so much. We will begin with questions from Counselor Eunice Ziegler.
Congratulations on your nomination. And thank you for taking the time to speak with me prior to today's hearing. Had a great conversation and just kind of kicked off that conversation with a question that I'll ask you in public forum. What gives you purpose? What is your intention for your leadership?
And I think, so we talked about this last night, so thank you for bringing it up again, but I think as I discussed in my statement, and I hope it gives a sense of who I am as a person. I have dedicated my career to public service. The only jobs that I've had outside of public service are waitressing and bartending to help supplement my income in public service, which I love too, but those are great times too. But I really have dedicated my life to public service. It's something that I enjoy doing. I know it sounds cheesy. I enjoy helping people. I enjoy the, I loved my time in the juvenile court over the 12 years working with kids and families. That's really where my passion is. And if confirmed, I'm excited to get back into that community.
So, in the courts, it's very, and we spoke about this, but it's, very complex. The cases that come before you. Can you speak about, your experience with trauma-informed approaches, how you would bring that to the courtroom as well?
Absolutely. So even what I've done over my career and even before starting the Massachusetts court system, I've worked with people facing trauma, and I've learned and I continue to learn about trauma through different trainings, through talking to colleagues, to living the experience with clients. And I know and recognize that trauma comes in many different forms. And I think it's really important for a judge to be aware of that. So what that means is someone in your courtroom that may be laughing or being defiant or being withdrawn, not making eye contact, not standing up, that doesn't mean that they're being rude or disrespectful. That's probably most likely a trauma response. So I think being aware of it and continuing to educate myself about that is really important. And I can, I plan to continue to do that.
So there are a number of resources that are available within the court that lend towards rehabilitation, restorative justice. What resources are you familiar with? What resources do you feel are lacking that you would like to explore deeper should you be confirmed?
I mean, there's plenty of resources out there. We can always do with more resources. Because resources need to be tailored to fit the situation, fit the child, fit the adult. It's not a cookie cutter approach. This isn't a baking, you're not baking something, you can throw it out at the end of burning it or not having enough sugar. This is real life and we need to get it right. So I'm familiar with, some of the resources in the community. If confirmed, I would absolutely be willing and able and wanting to get in touch with the resources in that community. And that's through working with, talking to probation, talking to people from the schools, talking to the litigants, finding out which resources are available. I also think it's important for judges to invite the resources from the community into the courtroom. So I think hosting brown bag lunches during the lunch hour and having the community resources come in and tell everyone about what they can offer, I think is really important. And it sparks that conversation about what other resources we can tap into for our families.
Do you have experience with cases involving housing insecure youth and families? And if so, what was that experience and how would you take that experience with you to the bench?
I think it's a really important topic. Many of the families involved in the juvenile court are facing housing insecurity, so that's a hot topic, and unfortunately. So it's making sure that the people that are working with these families are referring them to the correct resources so that they can attain stability. And also knowing, because I practiced in juvenile court, I know that decisions to remove a child disrupts that housing. Parents lose their housing once they lose their kids, and it's very hard to get their housing back. So I'm cognizant of that. That's something I would continue to look into, obviously, to see what resources are there. If there's things that, maybe aren't being tapped into, I can, make recommendations saying, hey, I heard about this program, so that the litigants know.
And so you have quite a deal of large breadth of experience. In your time practicing, do you have any regrets? Are there things that you wish you knew when you first started out in the field that you know now that will shape how you approach things?
I wouldn't say I have any regrets. I've actually loved every job I've had. Every job I've had, I literally can say that I woke up wanting to go to that job. So I don't have any regrets in that sense. Of course, you're always looking back and learning from the decisions that you make. And that's obviously something that I continue to do and would do as a judge.
And the last question is, based on, our different walks of life, we all carry some levels of bias. Can you talk about, what levels of bias you may have in your own leadership and how you would go about acknowledging them and ensuring they don't interfere with your work should you be confirmed?
I think it's really important to talk about bias. I think that we've come a long way in terms of being aware of bias. I think we all have bias. I'm sure I have bias that I check in with myself about. And that's something that I think we all need to do. And I certainly do on a daily basis, is just making sure that how I'm interacting with anyone or any decisions that I'm making are not driven by anything regarding bias. It has no place in a courtroom. And it's certainly something I would call out if I saw that.
Thank you.
Thank you.
Thank you. Counselor Kennedy.
Brought all my friends with you, so I'm not gonna ask you a lot of questions because I've obviously known you for a long time. And I've seen you in the courthouse, in the courtroom, over the years in Somerville, multiple days a week. And you do a great job there, and I'm sure you're gonna carry that over the juvenile court. I did note that you started as an intern in the Boston Juvenile Court. I started as an intern in the Boston Juvenile Court.
Oh, really?
That's where I started, yeah. And I worked with a guy who later became a juvenile court judge, whose brother's outside in the hall waiting for the next hearing, which was Peter Coyne.
Okay.
Yeah, wait, that was a little while before you were born. And most of the people in this room were blind. You're gonna be terrific. You do a great job in Somerville. You're gonna continue to be do a great job. When now Judge, then Clerk Foster was hiring somebody from that position, she actually asked me the recommendation then. You remember that? And I don't see any reason to change my mind.
Thank you. Thank you,
And
counsel.
oh, just one other thing. I don't know if you kids know how close I was to the grandmother and grandfather that I knew forever. Like over 45 years probably.
Bob. Thank you.
I'm all set, thank you.
Counselor DePaulo?
Thank you, Counselor. Good morning.
Morning.
Congrats on your nomination.
Thanks so much.
You have a lot of support. I read the letter from Justice Tan and obviously others have reached out and they speak to your fitness for this role. I like your experience. I just wanted to ask you some questions about working with the population you're going to be dealing with potentially as a juvenile court justice. So in your opening statement, you talked about a lot of the settings that you've visited and you've seen and you've worked with children who might be at, for example, group homes. I'm wondering have you seen multiple group homes? What's your impression of them? What's your impression? What I'm really wondering is what's your impression of the children's experiences there?
I've been in many group homes in many different cities all over the Commonwealth. Even though I practice primarily in this area, kids unfortunately are sent to group homes far away. So I've traveled all over the Commonwealth meeting with kids in group homes. And, you know, as with everything, there's great ones and there's not so great ones. So
How would you distinguish between the two?
I would, mostly it's staffing. Unfortunately, some of them just don't have the staff that have the life experience and training to work with this population. It's probably money driven.
Yeah, it's very stressful work too.
It is stressful work and there's a high turnover and that's not good when you have those relationships with the child.
It's low pay.
Yeah.
I wonder, I mean, does that impact the behavior of the children in those homes in your experience or?
I think it can. I mean, you can have a very young and experienced staff that's great.
Yeah.
Right. So it really just depends on each program. But yeah, of course it can impact how they're doing and how they're progressing and, if they're making, strides toward their goals, their relationships, because that's their home at that point.
Right.
So
And how things are getting reported back to the court from that home.
I would go in there a lot just
Yeah.
to see with my own eyes so I could report back.
You're saying you would in your prior roles or you would as a?
No, I'm sorry. As an attorney, I would spend a lot of time in those settings so that I could see and report and, advocate for what my client needed or wanted.
Right. And you noted that unfortunately, and it's typically resource driven, but unfortunately you noted kids are sent to group homes all over the state, far away from home,
Really far.
far away from school. You've worked with children who this has happened to, like what's the furthest distance or what's
The child in Northampton,
okay. But
that was a sexual abuse program for kids. There's
Okay.
not a lot of those.
so it's a specialized program.
Right.
Accessing.
That was hard. That's hard on the family if you want to maintain contact and you don't have a car and you know what I mean? So.
Absolutely. And I think, and you've also, I know in your resume, you've represented children who are CRAs, children requiring assistance. Did that come about when schools were referring kids or families, or how did you end up?
Both. So I represented kids on habitual offender cases that were filed by schools, a lot of truancies, and a lot of stubborn cases, which, the parents usually file.
Yeah. I'm wondering so necessity sometimes might put a situation where, let's say, a kid in state custody, a kid in foster care is sent somewhere, I don't know, over an hour away from their school, let's say. So they have to, but there's an emphasis on the continuity of the education, so they're staying in school. I just wonder, does that impact a kid's behavior in school when that happens?
It can.
Yeah.
You need to consider whether keeping the kid in the school is the right decision, whether that commute is the right decision for that child.
Yeah.
Sometimes they do move which is not great because then they're getting disrupted. So it's really kind of a balancing test of what works for that child. But yes, it can affect that, of course.
So I would think about I think about children I've worked with. So like if you're an adolescent being driven in a van an hour and a half in the morning to get to your high school and everyone knows it, and you're showing up at school and you're acting out, and the record you're building in school is being reported back to the court, and the judge is reporting that back to the student who already knows what the list was. And that's not, and we're using that behavior, which really is predictable based on the decision the judge made before, which isn't the judge's fault. The judge is dealing with a limited range of choices. But to not take into account that the situation that the child has been placed in is exacerbating the problems that were underlying, and to further punish the child, that's, that to me is what we're trying to avoid, I think, in the juvenile courts. What do you think about that? I mean, am I describing something that sounds realistic to you? Is this familiar to you?
I mean, I have seen kids placed in settings far from their schools. And even as a GAL, when I was the educational surrogate making those placement decisions, or that, using that placement advocacy, those are all considerations that come into play. But yeah, I mean, that does happen. And then you have to figure out what's the best thing and how long that kid's gonna be in that program too. So if it's just short term, then, then maybe they stay there, but.
SOAR assessment or something?
Sorry?
Sorry, when you said short term, you mean in the school or in the group home?
Well, in this group home setting. So it's really case specific.
Okay.
But yeah, I mean, these are challenges for sure.
They are for sure, and I've seen it play out with children in the courts, and I've seen children be held to very strict high account for behavior that we knew would have happened based on the prior hearing and the decisions that were made then. And so frustrating. And what I least like is when people get defensive about that, because it's like, we're all doing our best here. So we have opportunities here in this room to talk to future judges, and we care about what happens in our juvenile court. And so we want judges who demonstrate the thoughtfulness that you're demonstrating this morning, and who can at least acknowledge that things don't always go right. It's so frustrating when people tell me that everything's fine, but I know it's not fine. And we don't need to defend ourselves. Like, the system is doing the best it can. I'm very proud of our court system. Very proud of our court system. I've probably taken up all my time. Have I taken up all my
I
time?
don't think you have.
Oh, geez, I want to ask something. I want you to tell, can you tell the council
The
about?
answer is yes.
Counselor Kennedy yielded his time to me. And I'm always grateful for that. That's a standing agreement we have. When you were in the DA's office, you worked with community-based justice groups.
Yeah.
Is what I understand from your resume. Could you tell the council what that is, what that looks like, and why that kind of roundtable plays a role in our juvenile justice
Right.
system?
CBJ meetings.
Yeah. Who
So
attends? What's it like? What's the purpose?
I don't know how it is now, to be honest. But when I was a prosecutor, we would have CBJ meetings, community-based justice meetings, within the police departments usually, in that school community. And there were some school officials that would come and we would talk about some of the kids that are involved in the court system and what everyone's doing to support them.
Okay. I'll leave it at that. I was hoping you could elucidate a little further for people who already didn't know. Counselor Kennedy has had enough. Thank you for your time. Thank you.
Counselor Jacobs, thank you.
That
Well,
applies to you too. No.
I was gonna
I
say,
still have some leftover time I can say.
I'm in the mood to be indulgent.
Well, ironically, I don't have a ton of questions for you, partially because, as is often the case, my prior counselors have stricken off questions I was gonna ask, or close enough to what I was gonna ask, that your answers were great to listen to. I will ask you a couple of things. I'm not gonna give up all of my time. But first off, thank you for coming out. It was really great to sit down with you, get to meet you, get to talk. We talked about so many things that I really appreciated hearing your experiences about and thoughts around. I wanted to draw from your application both your undergrad focus on sociology and then a line on your answer to why do you want to become a judge, where you say, you know, juvenile court judges fortunately have options when balancing accountability and rehabilitation. And it's the word rehabilitation, which you do use a lot, and I understand why, but that I wanted to dive in on. Because with juvenile justice versus rehabilitation, when we're talking about the adult population, I feel like possibly we're talking about something different, but I don't want to put words in your mouth. So I'm curious, when you think about rehabilitation in the juvenile court, define it. Like, what does that mean, and what avenues are there, and what does it look like in practice?
So, I mean, that's a really important issue, obviously, in juvenile, because that's the goal of juvenile court, is to rehabilitate kids. So, you know, what that means is, you know, judges in juvenile court actually have the broadest discretion from any other judge in the Commonwealth. And there's so many different options. And when I say rehabilitate, it's, you know, figuring out why this child is before you, what led up to this, and how can we prevent this child from ever coming back? That's really the goal. And there's different options. That I will say there's a lot of diversion options now. When I was a prosecutor, there weren't. And that's what I talked about in my statement, the constraints of that role, because diversion at that time was very limited. It was only a certain amount of cases, and I don't even think victim cases qualified. Now there's an expansion of the DA diversion. We actually see it in our district courts with the emerging adults. And there's also judicial diversion through UIS. So there's lots of options to divert. And when I say divert, they are able to come up with conditions that are tailored. They're not cookie cutter. And I think that's really important because every kid is different. So that's what that's how I would define that to you. And that would definitely be something I'd be excited about learning more about. I've talked to Judge Ahern a bunch about this because I have been out of juvenile court for almost 5 years. So I'm interested to see, what's out there.
No, I appreciate that. And I'll add more context through a situation that I've seen play out. So and why sort of my question around rehabilitation, the use of that word when talking about young teens, children. But the situation, I'll give you the situation. A single mother raising a child with no extended family, father not around, substance abuse issues, overdoses in front of her 12-year-old, dies. That 12-year-old with no extended family becomes a ward and placed with a foster family. And prior to the OD, straight A student, engaged, despite growing up with significant challenges and trauma up to that point, fairly well adapted. Post that moment, spirals out of control, frequent flyer in the courts for all kinds of self-harm, self-sabotage, flight, substance use, hypersexuality, the list goes on. And the court continues to escalate consequences, addressing the behaviors, but from my view anyway, not really the root causes. And in the course of, and that's why some of these prior questions circle where I was going, but in a group home, sexually assaulted, sent to Key, stabbed and raped, the trauma keeps compounding, the behaviors keep escalating, the consequences keep escalating. And from a rehabilitation standpoint, I don't really see the framework where that addressed what was going on really to amend the behaviors. They really only until aging out in full, still in a swirl of trauma, trauma-driven behaviors that were destructive and counterproductive to finding a successful roof over. All of that to say, I'm curious about your thoughts about the discretion a judge does have in an individual situation to understand systemically from a root cause standpoint, what's before the judge. To be able to effectively use the resources you're talking about. To do the kind of so instead of using rehabilitation, the kind of healing. That I think a lot of times needs to happen, the calls for help that are being expressed through these behaviors that end up court-based, but for me are very much more psychology-based.
You need to take a holistic view of the child. And, I'm just kind of going off of what I said earlier, just about learning about what led this person here. And it sounds like maybe in your example, this person keeps coming back. So looking at what you've tried, tweaking that, trying to figure out exactly how you can support this young person, and just ensuring that there's enough positive people outside of the court that they can tap into as well, which is sometimes tricky. But just ensuring that, I think is really important.
No, I appreciate it. I will leave it there. Thank you very much for your time. Thank you.
Thank you. Counselor Civil, thank you. Good morning and congratulations on your nomination. And we had a wonderful conversation. And it was good to know that you were a victim witness advocate, and I know how that work goes because I was one.
Oh, great.
For a different district, which was Suffolk County. My question to you is, recently I've been noticing a increase in violence against children. And I'm really concerned of what I'm seeing, not only now in this present moment, but across the state. And I know in Massachusetts, we do not want to create broken homes. But what do you think would push you to the limit of removing a child from a home that is, involved in domestic violence or substance abuse, but anything that would protect that child from entering into that situation again?
And that's you're talking about everything ABC basically, right? So, the first you need to make sure that number one, you want to keep a family intact. From my representation of kids want to be home. Parents usually want their kids home. So you start with that premise, but if a kid is in, at risk of serious abuse, neglect, or harm, then you may not be able to keep that child there. But I think that there's ways to ensure that a child is safe with, safety. If it's domestic violence between parents, if the abuser has left the house, planning that, what that looks like. I think is important. But as far as, other things, there are conditional custody orders that can be crafted to ensure that kids are safe. So if parents are, meeting with DCF, going to therapy, allowing people into their house, the big thing is seeing, you always hear juvenile judges talk about seeing eyes in the situation. You want the kids being seen in the community to make sure that it's safe. But I think, it's hard to say exactly what I would do because it's very fact specific, but I think there's many times where you can ensure a kid's safety with having conditions in place and eyes on the situation.
Thank you. My last question for you would be, how would you define school to prison pipeline? And do you believe it exists in our courts?
I do believe it exists. And I think that's, you see that when kids are reprimanded and punished and disciplined for their school behavior, and that will just lead them down a path to criminal behavior. And I hope that we as practitioners are seeing that that's not necessarily the right thing to do in a school, to really look at the behavior and what's driving the behavior. There's no bad kids. There's a reason why kids are acting this way. So I think there's an awareness of that. Does it still exist? Yes. But I think we're doing better, but we can do better too,
Yeah. Great questions.
Thank you. It's good to see you.
See you.
I appreciate our conversation. I appreciated and valued and respected the depth of our conversation. There's just one point that I wanted to ask you about again. I had asked you about, what you thought kids understood about the world, and you said, they understand a lot. And I think respectfully disagreed and said, I think there's a lot that they don't understand. And I think you knew what I was getting at. I think we understood each other. My experience, and I would say it was before anybody here was born, but there's a couple of kids over there. It was before they were born. When I was practicing in juvenile court, my experience with working with those kids was there was a lot that they really didn't understand. So for example, a child who grew up in a neglectful home doesn't understand that that's not normal. And I felt it was really, really important for me as those children's attorney to help them understand that the reason they were in that spot where they were was because the responsible adults in their lives had not been able to meet their responsibilities. And I think that children, especially when they are in juvenile court, which I think I told you, I think should be called the children's court, because juvenile is kind of a pejorative. And we need to remember these are children who are in these courts. Children feel ashamed and embarrassed and guilty when what's really going on is that they didn't have the support they needed. So in my experience, there were occasionally judges who would kind of make that point for children, but I think that's a critical point for a judge to make sure that the children who appear before them understand. So can you speak to that?
Yes, and I think I missed the context of what we were talking about when we were talking about that, because I, thought further about that after we spoke. And, I just will say, when I was a lawyer representing kids and teenagers, I constantly did that behind the scenes, saying to them, this is not your fault that you're here. And I would hope that the social workers and other providers for them also reiterated that. I agree with you there. I don't think that came across when I spoke with you, but I did that all the time as a lawyer. In the delinquency context, that's kind of what we talked about a little bit. And I think, there's a level of accountability to some extent, but I think as a judge, you can just recognize that they're there, because of a bad decision. They're not bad. As I said to Counselor Civil, they're not bad people. They're not bad kids. This should not define them. This will not define them. And I think it's important for the judges to say that to them.
Thank you. I appreciate all that. This meeting is adjourned.
I'm going to start by reading a letter from the governor dated April 15, 2026. Dear councilors, pursuant to the provisions of Mass General Laws, Chapter 27, Section 4, I'm pleased to nominate Vincent J. DeMore III for the appointment of the position of the parole board member. Should the council confer its advice and consent, the nominee's term will commence immediately and expire 5 years from the date of the appointment. I appreciate your consideration of this nominee. Sincerely, Maura T. Healy, Governor of the Commonwealth. Now, before we start, I'm going to introduce the councils that are present. Council Ziegler, Council DePaulo, Council Jacobs, Council Dolan, Council Civil. Councilor Ianella and Councilor Ferrara are both out of town on business. I know the Councilor Ianella was at a government conference that we had to attend, so they couldn't be here today. But I know that they're going to view the recording of the hearing and make whatever decision they're going to make. And I know that they've both spoken to the nominee. Why don't we start by having you introduce the folks that you brought with you?
Thank you, Councilor Kennedy, and good morning, everyone. My name is Vince DeMore. With me today is my mom and dad, Vin and Dawn DeMore.
Welcome.
My dad's right there. My sister Jackie, along with my two nieces, Ava and Ella.
I might have some questions for your sister.
That's fair.
He knows you're the best, but go ahead.
And my wife, Marika.
How are you? Very good. And what we're going to do, and I had a discussion with Attorney Garen about this last night. There's a lot of people here and a lot of testimony to go through. So we're going to limit everybody to 3 minutes of statement, not you, but the witnesses, both pro and against opposition. So we're going to keep it down to 3 minutes each. I'm going to keep track of that and see if we can get through this in as professional and fairly, well, not draw it out. Let's put it that way. I don't want to make it sound like we're trying to make it too fast. We're going to start with your first witness. And you have, we have a witness list. Well, we'll start with Judge Coyne. I think he's here to testify for you.
Yes.
I've had to listen to him a few times in the past.
Yes.
Judge, have a seat.
That's the opposition.
That's the opposition.
Oh, thank you. I didn't have any. I said this earlier, but Judge Coyne retired. I found out that there's a different kind of trial, something called a jury trial.
He's kidding.
It's nice to see you too. My name is Michael Coyne, and I first want to congratulate the governor and her council, Judicial Nominating Committee, for taking the time to vet all of these candidates. And I'm sure it didn't take them long to come up with this candidate here, who I had the pleasure of knowing since about 2007, when he walked into my courtroom, not knowing where to stand, only because he was a brand new lawyer. And that lasted about a week before everybody got comfortable. But I never met anyone who has such a stellar reputation as Attorney DeMore has, speaking with people in the clerk's office, people with probation department, court officers, defense lawyers from his position as a prosecutor. They all have nothing but positive comments about him, as do I. He is one of the finest attorneys I've ever had the pleasure of working with. When I say working in a courtroom is a joint effort, in my opinion. I may have the best seat in the house. I may be the smartest guy in the room, the funniest guy in the room, depending on what the situation is. But the lawyers are the ones who run the show, in my opinion. Vince certainly ran the show for us when he was at the Boston Municipal Court. And looking at his office's public statement about their availabilities, I'm glad I never had to hire them, although if I did, I'd be hiring the right firm. He brings a lot to their job, having been both a prosecutor and a defense lawyer. He's well balanced, he's compassionate, he's very smart. And I can't not mention those two major matters that he handled. Not that he didn't handle many major matters, but cases that affected what we did every day in the courthouse were the drug cases that had to be reviewed under the so-called Annie Dukin case and the breathalyzer cases, which had to be remedied, that he used to do a lot of business on. And he was the right guy in that office to handle it. So I have nothing but firm support and admiration for him, and I certainly hope that you all will too. Thank you.
Thank you, Judge. Does anybody have any questions of the judge? Thank you very much. We appreciate you coming, as we always do.
Yes.
Okay, who was your next witness? I don't have a list.
Jason Owens.
Jason, good. Here we go.
Glad to see Jason.
Are you familiar with this gentleman? He's does a lot of great work at Roca. If you can introduce yourself and tell us just real quick about what Roca is and what you do there.
So currently no longer working at Roca. My name is Jason Owens. I currently run all the substance abuse and mental health services in the city of Chelsea. Prior to that, I worked at Roca for 13 years. I started off there as a volunteer in 2007, ended up as the director of the program. And part of my job was to create and maintain community partnerships with my young men were Court Street gang involved, and they would always bump up against the criminal justice system, whether it be Chelsea District Court or the police department. So I was to make some relationships out of those two agencies, which was not easy. And it took about 5 or 6 years of going down to court and asking the judges if I can advocate for this young person. Can I advocate? Can I advocate? And I was always told no, and asked to leave the courthouse a couple of times. Vince got the job as the head of the DA's office there in the court, and he took a meeting with me, and he sat me and listened to me, and he gave me a shot to start working with these young people through the district attorney's office to offer an alternative sentence, conditions of release that they would comply with Roca, and conditions that we set up for them. And we did it for years. That advocacy still is happening today in my current position, but we had to have worked through Vince. Now the judges started listening to us and they started talking to us, and we were able to run about, I don't know, so many kids, I can't even remember, over 100 young men that we were able to put through the criminal justice system in a different way, alternatively. Instead of locking these guys up, Vince was willing to take a look at the underlying causes which brought them there in the first place, and then address those underlying causes outside the courtroom, whether that be mental health, substance abuse, whatever the issues that they needed. We had those services at Roca, and he gave us the opportunity to work with these young men. Now, sometimes these guys would make 2, 3, 4, 5 time mistakes, and it still wasn't jail first. It was always another, what else can we do? And I gotta say, it was the highlight of my career working there, because I know what can happen if you take a shot on somebody and give them another chance. I'm sitting here today because a judge did it for me 22 years ago in federal court. Judge Mark Wolf gave me a chance, and I told myself that when I get out of there, that I was going to dedicate myself to doing this for other people. And my dream finally came true 5 or 6 years later into my career at Roca when I met Vince, and it still happens today, and it's happening in district courts all over the place. And we've actually modeled the way that we work in Chelsea District Court. We took it to different states. I brought it to Northern Ireland. I brought it to Ireland, England, Rio. We went everywhere with this, training police officers, youth workers, and people that work in the criminal justice system. And I'll be forever grateful, and it's an honor to be here today. And I'll end with this. I'm not a guy that learned this work in a book. You know, I did get a college degree later, but I served 13 and a half years of my life in prison, 2.5 locked up as a kid. And when I was a kid and I was ripping and running and getting in trouble, nobody was asking, you know, what your issues were, what your underlying causes were. It didn't exist. And I'm grateful that it does today.
I appreciate that. I am going to stick to the 3-minute rule, and you're there. And we appreciate, don't go yet.
Okay.
We appreciate your testimony. Does anybody have any questions? Thank you very much, and thank you for all that you do. I know what you do in the courts. I see it all the time.
All set?
All set.
Have a good day.
Okay, that will complete the folks speaking in favor of the nomination. We're now going to go to the folks that are in opposition to the nomination. And I am going to start with a person on Zoom. I know she's under the weather, and I told her I'd call her first, which is Jean Tronstein. Can we get her on here?
I'm here, just 1 minute. I'm trying to get my audio, my background, start my video for
We
you.
can hear you.
Okay, I just wanted to make sure I could start my video for you. Now you can see me too?
Yes.
Yes.
Okay.
Go ahead, Jean. Welcome back.
Give me 1 second before you start timing me, but I wasn't quite prepared to be first, but I'm happy that you did that. And good morning to you all, and good morning to you, Attorney DeMore. I'm ready now, Counselor Kennedy, whenever you are.
Go ahead. We're ready.
Okay, thank you. I am Jean Trouncine, a professor and writer who has extensively researched and written about parole for 15 years. I come before you in my capacity as both a professor and a writer, as my research has led me to oppose the nomination of Attorney Vincent DeMore, although I know he is a very qualified person in terms of a public servant. But the reasons that I'm opposed, others will mention his resume of 19 years as a prosecutor and ADA, and the lack of experience that we feel that he has in specific parole work with indigent clients, with substance abuse, forensic psychology, reentry challenges, and juvenile and emerging adult issues. I am most, however, concerned that Attorney DeMore will follow in the path of other parole board attorneys who left before their 5-year terms were up. Although she had a 5-year tenure, Gloria Ann Maroney moved on to seek a judgeship 3.5 years after serving as board chair in 2022. Joshua Wall was board chair in 2011 and became a judge 3 years later. When my then counselor, Eileen Duff, asked Paul Tressler if he would commit to serving the full 5 years of his term as chair, Tressler said he would not, because he did not know what would happen in his life in the next 5 years. When Duff asked him if he wanted to be a judge, he said, I don't know, maybe, I don't know, never applied. Less than 4 years later, Tressler became a judge. I would like the counselors to ask this question of Vincent DeMore. Will you commit to your full term of 5 years on the board before seeking a judgeship? In another point, one of my articles researched for 6 months, I became aware that the governor's counselors made a very courageous choice to vote down parole board nominee Shakita Hossain, who was not qualified to serve as a board member. She had an excellent record also as a public servant, but she had not attended parole board hearings or deeply researched parole issues, and she understood very little about what those who sought parole needed in terms of support. The parole board needs your courage now. When Tina Hurley was chair, the paroling rate was 65.8%, a healthy rate of balancing the needs of parole applicants' freedom with society's safety. Now the board's paroling rate is under Chair Gomez is 57%. The board has a forensic specialist, a member with social work experience, an attorney, and 3 people with law enforcement backgrounds. We do not need someone with the experience of DeMore at this point in time. We need someone with the experience I
Jean, I'm gonna have
described
to
above.
ask you to wrap up because you're just a
I'm
little over.
wrapping up. Let me get my last sentence out. And I urge you to vote no on Vincent DeMore's nomination. Thank you very much.
Thank you very much. Does anybody have any questions? Thank you, Jean. It was good to see you again.
Thank you.
Okay. Now, next, we're gonna call Betsy Chase. Oh, there you are.
Hello, good morning. Thank you for the opportunity to testify in opposition to this nomination. I submitted a more detailed version of testimony in writing late yesterday. My name is Betsy Chase of Cambridge. I'm here not in my professional capacity, but in my civic capacity. I've seen a lot of prosecutors in action. I've sat in courtrooms nearly 100 times, accompanying loved ones and community members. I've attended over a dozen lifer parole hearings, and I've read many more decisions. Each hearing begins with examining growth and transformation that happened over decades. Then a prosecutor makes a statement, ignoring all that has been said, as if it were the arrest day press conference on a monster just stopped from a rampage. Never does the prosecutor acknowledge that a human being can change. I was at a recent lifer parole hearing with a petitioner who's in college, who runs youth groups, who helps people leave gang life and has tremendous family support. The father of the victim testified that it's time for this man to come home. The prosecutor then stood up with the same old song and dance about this dangerous monster. He had the audacity to say that if the victim's mother were still alive, he's not so sure she would agree with the father in asking for release. Nothing I have seen has led me to believe that someone whose professional life has been predominantly as a prosecutor will have developed any of the skills needed to be a qualified member of the parole board to assess rehabilitation, emotional development, reentry readiness, substance use, or mental health. The same could actually be said for a lot of defense attorneys. This council expressed significant concern last June about confirming a third member of law enforcement to the parole board. That candidate's community endorsements and experience with reentry via parole ameliorated those concerns. Prosecution has nothing to do with rehabilitation, brain development, personal growth, managing triggers, or assessing community support. A prosecutor does not belong on the parole board, even a prosecutor that's become a defense attorney. His confirmation would make the board nearly 60% law enforcement. As Councillor Ianella said in June, the only way the board is ever going to change is if this body stands up. I urge this body to stand up and tell Governor Healy to return to her pool of candidates and put forth someone with the qualifications the parole board requires. Thank you.
You read your letter?
Yes.
We read it last night. That's pretty much what you said today. It was very, very well thought out. And you also did it in under 3 minutes. Which is terrific. Does anybody have any questions?
Thank you.
Thank you very much. We appreciate it. And next, we're going to call Olivia Dubois, if I said that correctly.
I think so, yes.
Welcome back. You've testified here before.
I've never been here.
Okay, well, welcome.
Thank you. And never being here before, I am a little nervous. I don't usually publicly testify in things.
No bite.
So my name is Olivia Dubois. I'm a licensed independent clinical social worker. And I recently founded an organization called Beyond Defense, where I integrate clinical social work and lived experience into legal teams. Prior to that, I worked at the Committee for Public Counsel Services for 11 years, where I served as the Director of Social Services Advocacy in the Environmental Litigation Division. And I also worked with the Rafferty Defenders Unit for about 8 years. I have over a decade of experience working with individuals who are system involved, many who are indigent and impacted by intersectional forces of poverty, race, and policing. I've conducted hundreds of biopsychosocial assessments, written reports, and worked directly with individuals both during incarceration and as they prepare for reentry. I say this to ground my perspective in direct clinical and systems level experience with the very population the parole board serves. And today, I'm here to respectfully urge you to decline the nomination of Vincent DeMore for the Massachusetts Parole Board. The Parole Board is tasked with making forward-looking determinations about whether an individual can be safely released, whether they are able to live in the community without violating the law, and whether their release is compatible with public safety. I believe this requires deep engagement with people directly impacted, deep knowledge of community-based resources in order to understand reentry readiness. Mr. DeMore's professional background does not reflect the multidisciplinary rehabilitative expertise necessary to carry out this responsibility. While he has experience in criminal law, there's no indication from what I know that he has extensive experience working with indigent clients, the population that makes up the vast majority of those who come in front of the board. Meaningful parole evaluation requires understanding of structural inequities as well as direct experience with incarceration, limited resources, and reentry barriers. Parole hearings routinely involve people with complex trauma, mental health conditions, substance use disorders, disabilities, and those whose offenses occurred during adolescence and emerging adulthood. Evaluating these cases requires a clinical and developmental lens. I'm going to move through my testimony a bit because I'm worried I'm going to go over 3 minutes, but we know the Madison Diachenko decisions happened. We know that requires an understanding of neuroscience and, most importantly, transformation and changeability. I don't know if this council is as familiar with Crowell cases, but these are cases where people have the right to counsel as it relates to them having disabilities. And these disabilities can be intellectual, they can be people with chronic severe mental illness. And we need to have a parole board member who understands how that shapes behavior and rehabilitation and what resources are available to people with complex needs. Effective parole decision-making requires a grounded understanding of incarceration and reentry, how individuals engage in programming, how they change over time. And there's no indication that Mr. DeMore has direct or sustained experience working with individuals in incarcerated settings or understands the programming. I have to just note again that many others wish to join us today in testifying in opposition, as well as signing on to the letter that was provided to this council, and were unable to do so.
If you could wrap up, you're a little over just.
Yeah, sorry, they were unable to do so due to legitimate fears of retaliation or risks of their liberty. These include parole petitioners, individuals currently living on parole, as well as attorneys and legal team members working within that system. I even had a client say to me yesterday, well, this is where the doors close. I guess we had an opportunity and now it's gone.
Anybody have any questions? Thank you very much for your testimony. It's appreciated. Next, we're gonna call Stacy Borden. Come up, have a seat.
Good afternoon.
Nice to see you.
Wonderful. How you doing? I'm Stacy Borden. I am a formerly incarcerated woman. I'm also the executive director of New Beginnings Reentry Services. And I am gonna try to be under the 3 minutes. I hope you give me.
Waiting.
I come before you today, not only as an advocate, but as someone deeply rooted in the realities of incarceration, recovery, trauma, and reentry. I also come before you as someone who ran for governor's council to help bring.
Not everybody has good judgment.
I had 34% of the vote. I was almost there. To help bring greater awareness, accountability, and public engagement to this body and its decisions. Our communities deserve transparency. And yet, too often, these proceedings remain disconnected from the people most impacted. I rise in strong opposition of this nomination of yet another law enforcement agent to the parole board. At some point, we must ask ourselves, who is parole for? It is merely another extension of punishment, or is it intended to be a pathway toward accountability, rehabilitation, and successful rehabilitation or reintegration? Because if parole is about public safety and second chances, then the board must reflect those values. We do not need another person whose professional lens has been shaped by only prosecution, surveillance, or enforcement. We already have enough of that perspective embedded throughout the criminal legal system. What we need now is balance. We need individuals with lived experience, people who understand incarceration, not as theory, but as reality. We need individuals with clinical backgrounds in mental health. I have a license in mental health and I'm also a substance abuse counselor. We need substance use disorder treatment, trauma, recovery, and behavioral change. We need people who know how to access readiness for reintegration, not simply risk through fear-based assumptions. Effective parole decision-making requires a grounded understanding of the realities of incarceration, institutional behavior, and genuine program participation. Excuse me. Many former probation officers, prosecutors, and parole agents have never directly provided support to people while incarcerated or upon release. They know supervision, but not necessarily restoration. And that distinction matters. I understand members of this council have previously stated the desire to appoint individuals with lived experience and backgrounds in mental health, substance use, and poverty. If that is true, then this nomination contradicts those stated values. This nominee will tell you that he is a criminal defense attorney, but let's be clear. This is a major difference. There is a major difference between defending ordinary citizens accused by the state and representing police officers accused of excessive force or unconstitutional actions against our communities. Those are not the same thing. This nominee represents law enforcement interests from both sides, a former prosecutor and a defender of police misconduct cases. That is not balance. It is layered bias. It's further entrenchment of the same power structures that have harmed communities for generations. We are comfortable over-representing prosecutors, but hesitant to appoint those who have zealously defended constitutional rights, fought for poor communities, and challenged injustice.
You could wrap up now.
Why are we willing to trust those who punish than those who heal? This is unacceptable. The people of Massachusetts voted for change. Many of the newly elected councilors ran on promises of transformation, accountability, and justice. Today is the day to prove those promises meant something. Reject this nomination. Demand a candidate who understands rehabilitation. Demand someone who knows reentry. Demand someone who, with humanity, lived experience, and clinical insight. Demand a parole board that believes people can change because lives are on the other side of these votes.
Thank you very much. Next, we're gonna call on Matt Hudson.
How you doing? So my name is Matt Hudson, formerly incarcerated 33 years. I work for Prison Legal Service, a part of the community liaison. I am the community liaison / paralegal for the Racial Equity and Correction Initiative. And I would strongly advise this council to reject this nominee. For reasons that's already been stated, and I don't really want to belabor a whole lot into it, but the reality of it is that there should be more justice impacted, or at least behavioral scientists that's on the board that can make the rehabilitative assessments. I know that the governor has moved towards some of this, but we are still left with someone that's not representative of a justice impacted individual who could understand what it's like internally to be within the Department of Corrections or a state or a correctional facility that can guide the parole board in understanding some of the things that take place there, like retaliatory things that happen as a result, or over sanctioning of disciplinary on Black and brown folks, which is what they experience day in and day out, or how they're being deprived these fundamental rights day in and day out. And this nominee, who would have no experience in understanding that or knowing that, wouldn't serve to that end, in my humble opinion. And so I would ask that this nominee be rejected. He does not represent what I would consider to be a holistic approach in which the parole board has been going. And I think we need to maintain that balance and force the governor to actually put someone up that reflects all of our community. Thank you.
Thank you for your testimony. Does anybody have any questions? Okay, thank you. I saved the best for last, Patty Young. Who's testified before this council many, many times over the years. And always has a lot to offer.
Just briefly, I've been a criminal defense civil rights attorney for 42 years. I'm old.
Me too, 42 years.
Years.
I'm not old.
For the last 30 years, I've also run the Northeastern Law School Prisoners' Rights Clinic, and in that role, I appear in front of the board with my students approximately 20 times a year. I also work as a mentor at CPCS, training people to be parole attorneys. I work in community groups, and I work with the legislature, helping them to form new legislation. So I'm pretty much all about parole. And I'm not going to repeat all the things people have said because I agree with these witnesses completely. Mr. DeMore is a nice person. Lots of criminal defense attorneys said, yeah, he's one of the easier people to work with. I like working with him when he's, when he was prosecuting. He's okay. But he's not qualified to be on the parole board. You don't want another prosecutor on the parole board. I could
go on about prosecutors on the parole board. I've lived through all of them. It's been a horror story from beginning to end. The only one that I ever really liked and got along with was Maureen Walsh. She was great. After that, it was bad news. Their parole rates were terrible, but I won't dwell on that. I'm going to tell you one story that will give you some insight into why you don't want a prosecutor. Because in my mind, somebody who's been a prosecutor for 19, 20 years, that's who they are. That's part of their life. That's how they see the world. They see the world through prosecutors' eyes. Of course they do. That's what they've been doing with their job. Mr. DeMore did that when he represented the petitioners in the mess of Dukin cases, which was called Bridgman. The Bridgman case went up to the SJC because what had happened is after the parties had identified 22,000 people who were affected by Annie Dukin's misconduct at the lab, they had to figure out what to do with the 22,000 cases because all of those convictions were unjust. I mean, at least from the petitioner's point of view in the courts, those had to be challenged. And so the decision was they would notify the people, and the decision was that they would work with the single justice to get together a notice to send out to people and tell them what their rights were and what they could do. But the Suffolk DA's office with Mr. DeMore sort of jumped the gun and sent out their own notice ahead of time, and it's set forth in the.
Time's up, but I'm gonna give you another minute and a half.
Oh, I'm up already? No.
Go ahead.
All right, then I gotta get to the end of this.
No, you're getting another minute and a half. Go ahead.
Fast. What happened is the notice went out, was so badly written. I'll send you the site to the case. It didn't tell people their rights. It didn't tell them what's going to happen to them if they don't challenge their conviction. The Spanish version, could quote the court, but the court says the Spanish version was so unintelligible, a Spanish person couldn't tell if it was written in Spanish, couldn't read it. It was horrible. Then what happened at the hearing, in the briefing and before the SJC in trying to figure out a remedy? Well, the Commonwealth opposed a global remedy. They wanted the cases to be handled 22,000 of them one by one. I don't think you would ever see any justice, but their rationale for doing that, and I'll try to read it. It's that so few Dukin defendants chose to respond to the letter because they were not interested, quote, not interested in reopening a closed chapter in their lives. No, they couldn't understand the notice. They didn't know what was going on. The court found that, and the court pointed out that the notice never told them they could be deported, they could be barred from public housing, they could be barred from subsidized housing, they could not get certain jobs and professions, they could end up being homeless and unemployed, they couldn't get government benefits, cash assistance, unemployment benefits in some cases, they could get stronger penalties for drug offenses. That's the prosecutor's way of looking at something like this. Instead of a social worker, a thoughtful person, this is what will happen. He's a nice person. He should not be on the board. And the Dukin case is evidence. This is recent. The Dukin case, well, this is from 2017, but the case went on for years and afterwards. So it's a problem. It's an ongoing problem.
Just in terms of your notice, I think a lot of those defendants never got them. They moved, they changed.
How wrong the addresses were. And
I agree with that, that a lot of them just never got them, never knew about it, but I appreciate your testimony, as always.
Point that takes 10 seconds to say, which is a new board member takes at least 2 to 3 years to change and to get into the swing of things and to do things right. Any board member will tell you that.
Right.
When you come on the board with the intent to become a judge, it's 2 to 3 years of training that's worthless, and then you go on.
Yeah.
It shouldn't happen.
That's fair, and one of the things I'm gonna ask him to do when he gives a statement, go off script a little bit and address that issue, as well as address the issue that everybody is talking about, that that they believe he has a prosecutorial background and comes from that type of background that doesn't suit him. That's what he has to address. He will be prepared to do that. Thank you for your testimony. All right, is there anybody else who either wants to speak in favor or in opposition to the nominee? Hearing none, the floor is yours. And I will ask you to address those issues that they raised. And obviously, that's a big part of what this hearing's about.
Good morning. I'd like to first thank Governor Healy and Lieutenant Governor Driscoll for the opportunity to be here today. Thank you to the members of the Governor's Council for taking the time to speak with me prior to today's hearing. I'd also like to thank the Governor's staff for their hard work, dedication, and support. Thank you to Sonia Altamirano and her team for shepherding me through this process. I'd like to thank the current members of the Parole Board and Parole field staff, all of whom have been overwhelmingly supportive and helpful to me. I'd like to thank the witnesses who came in support of my own nomination today, Judge Michael Coyne and Jason Owens. I'd like to thank my parents who've made countless sacrifices for my sister and I, and who are here with us today, along with my sister and my two nieces. And most importantly, I'd like to thank my wife, Marika, without whose support and counsel I would be nothing. For as long as I can remember, I have cared deeply about public service. The desire, drive, and calling to serve my community has been deeply ingrained in me. It's my belief that each of us have an obligation to hand our community off to the next generation in better shape than that in which we received it from the previous generation. And for the entirety of my professional career, I have sought to do exactly that. At every turn, I have looked to use what talent and skills I may have to find the way that I could best help my community. First, as an assistant district attorney, I served the residents of Suffolk County by providing principled and compassionate counsel. I worked closely with community partners, extending the reach of my work far beyond the courtroom to help those living with mental illness, striving to overcome substance use, or working to navigate a system which all too often seems designed to trap, frustrate, rather than uplift and encourage. I worked intensively in our juvenile courts, seeing firsthand the practical impacts of juvenile brain development and the unique challenges that young and emerging adults face. In the evenings, I was fortunate to have the opportunity to teach in the Chelsea Community School program, teaching English to speakers of other languages and civics for the citizenship exam. My students, who hailed as far afield as San Salvador, Marrakesh, Phnom Penh, or Shanghai, walked away from those classes with, I hope, a better grasp of object versus subject pronouns and the system of checks and balances. But I walked away from those classes with a profound understanding and frankly an awe for the hard work and perseverance of our newest neighbors. More recently, for more than 7 years as a defense attorney, I've had the opportunity to make an impact on an individual basis, whether that be the young man charged after he suffered a medical episode behind the wheel of a car, resulting in an accident in which his own grandmother succumbed to her injuries, the father of 2 who found himself placed under arrest just days before his citizenship interview, or the combat veteran of 23 years of federal service facing charges which would result not just in his separation from the Army, but also the forfeiture of his retirement. All of those cases and many more to boot illustrate that each of us are more than our worst moments. All of us are more than our lowest points. 5 years ago, at the age of 40, I looked to serve my country as I have served my local community, and with the support of my wife, I shipped off for basic training with the United States Army. Serving my country has been the honor of a lifetime, and for the last year, I've represented victims of sexual trauma as they navigate a military justice system, which can at times be opaque and has historically turned a deaf ear to survivors. Whether as an ADA, a defense attorney, a teacher, or a soldier, I've always comported myself with the belief that public service is fundamentally a customer service business. And while that does not mean that the customer is always right, it does mean that the customer is always respected. I bring that same approach to my work on the parole board, ensuring that every client and every survivor feels heard and is treated with dignity. Service on the parole board represents an opportunity to use my diverse experience and marshal the many voices I've heard through the years to positively impact my community and continue to lead with empathy and respect, to augment public safety through a compassionate and principled approach to recovery, rehabilitation, and reentry, to respect the voices of victims and survivors while never forgetting that all of us are more than the sum of the decisions we make. If I am honored to receive your support, I will approach each case on its own merits, and I will always be mindful that our system of all human endeavors is flawed and imperfect. Parole is embedded within a larger system, which is both a product and a cause of system-wide and cumulative racial and class disparities. Many of our policy choices result in communities which are at times over-policed and over-surveilled. And our system as a whole privileges finality over accuracy. I promise I will continue to listen and to learn, and I will always value the dignity of our clients and the importance of second chances. In short, I will do everything in my power to use my service on the board to make our community a better place for the next generation. Thank you.
Thank you. Council DePaul.
Thank you, Council Kennedy. Good morning.
Good morning, sir.
Congrats on your nomination.
Thanks.
Let's talk about the parole board. When you're sitting on the board potentially and facing a parole applicant, what do you perceive to be the biggest barriers to that applicant's potential reentry into our communities?
Well, I think each case is going to be different based on the unique facts and circumstances that particular applicant is going to face. Not every applicant has the same suite of challenges that they may face. Certainly substance use is oftentimes a challenge. Mental health challenges are frequently there. In the case of someone who either in that particular case or in a previous case has been adjudicated guilty of a sexually based offense, they can face some real serious housing issues coming out because of the classification system that we have. And of course, you know, to what extent has the individual, had impacts with regard to their own sort of cognitive development, both prior to the case in chief that brought them to where they are at that moment, and also as a result of the actual process of the trial and the incarceration itself. To what extent did that trauma sort of further impact an individual? So I think those would be among the factors that I think would be important.
So as a board member, how would you imagine evaluating how those barriers would be faced by the particular individual? You know, noting, as you noted, each individual has their own individualized case, of course. How do you think about those barriers relative to the individual? How does it impact your decision?
Yes, and sir, I think the key word that you use there is individual. You know, we do a great job with this in the education context, I think, with IEPs, right? Where we certainly have the will and the desire to develop and tailor individual educational plans for students. And I see no reason why we can't be doing the same thing with respect to someone who's a client before the parole board.
Well, so that's a great segue. I mean, in a lot of ways, crafting conditions of release are comparable to let's say, evaluating the accommodations that a student might need on an IEP plan. So when we're thinking about conditions of release, there's a lot of talk, there's historically been a lot of talk, and I think there is presently talk amongst the board and in the department about the kind of standard conditions of release that are used. Are you familiar with the kind of standard set of conditions that are used by the parole board right now?
I am, sir.
And there's my understanding from talking with board members and from a lot of folks in and around the issue is that there's a lot of talk about changing those standardized conditions because, as you know, things should be individualized. What about those conditions would you change as they presently stand?
I think I'm not in favor, generally speaking, frankly, of standardized conditions of release. I think they are imposed reflexively. I think that we certainly have the time and the resources and the energy available to do individualized conditions. But to the extent that those ought to be.
I'd pause for a second there. My understanding is the board is very overworked right now and historically has been, and that there's a backlog of cases and that as hard as the board and the department are working, and I think they've made great strides, both under Chair Hurley and under new Chair Gomez, to try to address that. I think they're very strained. I think they're under a lot of pressure to try to individualize these things.
No, certainly there's absolutely bandwidth issues present at the board and frankly in all of our various state agencies. That said, I don't think we ought to essentially rely upon that for why we're not tailoring individual responses as best that we can. So, I think you have to look at, for instance, the extent to which you can be in the presence of persons who have been previously court involved. How does that impact someone's ability to be with their family, right? With their housing situation? The conditions that you remain drug and alcohol free, while I suppose should be aspirational for all, I think can present some difficulties in terms of the sort of practical realities of life, of family celebrations, of holiday celebrations. And I think those are among the ones that we could certainly take a look at.
When you're, as a board member, when you're evaluating parole applicants, you're taking into account the risk needs assessment that's been provided to you, to the board members. You're taking into account work opportunities, education or treatment programs that have been available during incarceration, and then demonstrated good behavior. That's what the regulations, that's what our Commonwealth's regulations say you're looking at. So let's look at a couple of those. Work, education, and treatment programs in our incarceral facilities. How do you evaluate a particular individual's resume of availing themselves of such programs? How would you evaluate that? Before I even give you the list, how would you evaluate what you're about to see? What goes in your mind when you're looking at that person's incarceral record?
I think it's important that you balance it against the opportunities that they've had, right? Not every facility is the same with regards to the opportunities that folks have to participate in that programming. It's, I think, entirely unfair to hold it against someone that they have not availed themselves of programs that simply do not exist. So I think that's an important factor.
I think that's like an impossible situation. So we're supposed to look for someone's, what, as you said, what they've taken advantage of is whatever the opportunities might be. But if the opportunities aren't there, of course, we can't hold it against them. And yet I'm supposed to, and yet the regulations are telling me to use this as a factor in determining my decision. So, I mean, that's what you're going to face as a board member, potentially. How do you address that? So if I'm an applicant who says, yes, I'm on the waiting list for 12 programs, and I tried to get into this education program, but I'm not in any of them, or maybe I did one, but I'm on the waiting list. I've tried. So how do you evaluate that?
Well, that's where you weight them, you weight these factors differently based upon those opportunities. If there's no lack of effort, no lack of trying, then I think you have to weight that factor differently.
How do you weigh admissions of guilt on the part of a applicant in making your determination?
So I don't think anyone in this room disagrees with the notion that there are undoubtedly people serving sentences today who in fact did not commit the offense for which they have been convicted. I don't know what that percentage is. It is certainly greater than zero. I think.
Does that mean you will not ask someone for an admission of guilt?
I think it's a minimally important factor, sir. I think at the end of the day, what's more important is what sort of programming they've attempted to take advantage of, what sort of opportunities are sort of set up for folks afterwards, what kind of a runway have we created for them? I think those are the critical questions in terms of where do we go next. And I think placing someone in a catch-22 where their choice is either between undercutting their own attempts at exoneration or availing themselves of the opportunity of parole, I think is fundamentally unfair.
Okay. Have you ever attended a lifer hearing?
I have not.
When you attend a lifer hearing, the entire board needs to sit. Some suggest that maybe we should revisit that fact in order to address the overworked nature of the board that I mentioned earlier, that perhaps we could find a fix so that the entire board doesn't need to be present for every lifer hearing. So that would free them up to address the backlog of cases. But that's a side issue. When you're at a lifer hearing, there's the opportunity for victims or the family members of victims to present the statement. How would you, and they're often very emotional, obviously, and you know this as a former prosecutor. How do you weigh a victim statement or a victim family statement in your determination as a parole board member? Does that factor into your decision at all?
I think it's important that every victim or survivor who comes before the court, and particularly in the lifer hearings where we're talking about, that there has been someone who has lost their life, right? So it's whether or not this person before us today is factually the person who committed that offense is neither here nor there so far as the victim or the survivor.
So how does that statement impact your decision as a board member?
I think it's important that they are listened to, that they are given that audience, that they are granted that dignity and that respect. At the end of the day, sort of apropos of what we said earlier, the customer is not always right? We don't cede the decision-making process to victims and survivors. They have input, they're granted input. The legislature has determined that be the case. I think it's important that we listen to their testimony and that it have some weight. But in the grand scheme of things, I think it's impossible to weigh that anywhere near what you would weigh the rehabilitative efforts and the ultimate reentry program that's been put in place.
One of the reasons for the heavy workload on the board right now is the recent deluge that happened when the Mattis decision came down from the Supreme Judicial Court. And for those who don't know, the Mattis decision made many folks currently incarcerated who were previously not eligible for parole, all of a sudden eligible for a parole hearing. And so there became an instant backlog of folks waiting for a parole hearing, should they choose to apply or petition for one. So I'll start with what's your take on why Mattis happened, on why we're dealing with Mattis right now? Like, what do you think of the jurisprudence there?
In terms of my view on the case,
Correct, yeah.
it was a natural outflow of Diachenko. I see no way that you do not reach Mattis after you reach Diachenko. And candidly, the line will likely be drawn elsewhere in the future by the SJC. Whether you draw it at 18, you draw it at 20, you draw it at 24, you draw it at 25, you're drawing a line. The bottom line is that the science is continuing to advance with respect to how cognitive development and juvenile brain development and young adult and emerging adult brain development is viewed. And as that science continues to move forward, I expect the court will continue to keep pace with that.
And then talk to us then about your current understanding of brain development as it applies to the criminal justice system.
It impacts the risk reward assessment that folks make. It impacts impulse control. It impacts the ability to resist peer pressure factors. I in fact, was once 16 or 17 years old myself some years ago. And I distinctly recall working through those things myself in those days. And I think all of us in this room have done that. It's just that some of us were more fortunate than others to not have some very bad outcomes as a result of the very bad decisions we made as children. So, I mean, I've seen it, you know, when I arrived in the Chelsea District Court and I took over the juvenile docket, we had something like 200 cases on that docket. And I remember looking at it and I said to myself, and I think the statute of limitations is well run for my involvement. I remember looking at these and saying, gee whiz, I grew up in Revere and Chelsea and I did some of this stuff. You know, I'm not sure these folks need to be court involved. And I think I pared that docket down to maybe 25, 30, 40 cases, something like that, because, you know, and it was part and parcel of the larger efforts that we made in Suffolk County at that time to really focus on juvenile diversion. And I'm very proud of the work we did there.
The parole board is also, why is the term escaping me? The Board of Clemency? The Advisory Board of Pardons. What is your perspective on clemency? How does it fit into our justice system? Is it used at an appropriate level in your estimation?
No, is the short answer to that question. I think that the governor's clemency guidelines reflect a position, a well-reasoned position, a position that I share, that in the criminal justice system, there are tools available to correct unfairness, to correct injustice.
Let's start with racial injustice.
Sure.
So how can the parole board in its role as advisory board of pardons, ultimately, of course, relying on the governor to make the decision to send the pardon to the governor's council for our consideration, how can the advisory board of pardons advance racial justice, or more particularly address past racial injustice?
When you look at the studies that talk about the disparate impact with regards to sentencing, they control for the various variables that someone might look at, you know, the nature of the offense, the nature of the person's individual previous court involvement, all of those things, and they still result in disparities which are not insignificant. They're statistically significant between white communities and let's say Black and brown communities. And so the clemency guidelines and the clemency opportunity there is a chance to correct those things, right? To essentially go back and revisit those sentences on an individualized basis in order to correct, frankly, those injustices. And it's an area where I think the bar, frankly, could do a much better job in advancing those petitions. I have represented people on pardons, and you know, I think it's an area where we absolutely the board can do a better job, I think, of messaging the availability of those remedies to the larger legal community. And I think that's a clear area of improvement.
Thank you for your thoughtful responses to my question. I have one last question before my time is up, and it relates to what came up before your statement. And that is, my understanding is you've applied to be a judgeship in the past.
2.5 years ago, thereabouts.
So, you know, sitting on parole board, there's a lot of weighty decisions that go on. If there's been instances where parole board members have come under intense public scrutiny for decisions or things that have happened relative to decisions they've made. Should I be concerned, and forgive me, I don't think you addressed this in your statement, but if you did, then indulge me by repeating. Should I be concerned that someone who sees a judgeship as a one possible path in their future would be restrained in their decision-making because, and exhibit extra cautiousness, shall I say, in anticipation of applying for future positions?
Anyone who wants to be a judge who's afraid to make a hard decision should not apply to be a judge. I think it's a bad line of work for you because it's a line of work in which you make hard decisions. I've made hard decisions for 19, 20 years in my career, and I pledge to you I will continue to make hard decisions.
Thank you. I appreciate it, Counselor. Thank you for your time.
Thank you.
Thank you.
I assume it's my turn.
I did, I just said
Oh,
it.
sorry.
You didn't hear me. Oh, if you can't hear me, here, take these.
I'll take them. I might need them. Hello, it's good to see you. I feel like I just saw you. Thank you for taking the time last night to sit down and talk with me. It was definitely an interesting conversation and you have an interesting resume. You've got an interesting background. It is broader and more nuanced than what's been suggested today. And yet, I don't think you were mischaracterized in your experience either today. But I do want to thank you for your service. And there's a bunch of other unique elements to your background that it was interesting to discuss with you. I want to start really basic. Why do you want to be on the parole board?
And I think I addressed a lot of those things in my opening statement. It is an opportunity for me to marshal all of those various areas of experience. I think my time working for the Suffolk District Attorney's Office, I think, is significant. Certainly lots of time there in the criminal justice system generally, lots of time working with community partners, as you heard from Mr. Owens earlier, time working inside of the juvenile courts, and also tackling some difficult and thorny, larger systemic issues, which as those continue to face and challenge the board, I think I'm well positioned to bring that experience to bear. My experience working with individual clients, which I know that it is not the focus of my practice, but I do indeed represent indigent clients. I have 3 indigent clients on the appeals side right now, including some who are incarcerated. I was at the NECC not 3 weeks ago, meeting with a client. So I have that experience as well. My experience with the Army, which presently in my capacity as a special victims counsel, but previously at the earlier commands that I worked at, is all about empathic communication, is all about trauma-informed relationships, trauma-informed approaches to folks. And I think the parole board gives me an opportunity to marshal and use those tools, frankly, in furtherance of the board's mission. I think I may have used this expression with you last night, but my work as a prosecutor was a mile wide and an inch deep in terms of what I could do in terms of impact. My work as a defense attorney is about an inch wide, but a mile deep in terms of impact. And the parole board offers me an opportunity to merge the two together and have a greater systemic impact to really help my community.
So why, I'm lacking a full sense of the motivation. I understand what you're saying, but why do you think this level of experience is what the parole board needs in this moment?
I think the parole board would do well to have a diversity of voices on the board. And as it presently stands, there really is no person on the board who has certainly any substantial post-conviction experience, which I do, both when I was with the Suffolk DA's office and also as a defense attorney who I've represented folks on post-conviction matters. So I think that diversity of experience, I think, can add a lot of value to the board. And as I indicated in my earlier statement, my entire ethos of public service is finding the areas where I can maximize the value that I bring in order to improve my larger community, in order to make this a better place to live. And I think that the parole board is an excellent opportunity for that. And that's why I explored this opportunity. That's why I'm here today.
What do you say to what we heard today, that the board could really benefit from any number of diverse experiences and perspectives, inclusive of someone with lived experience having been incarcerated, someone who's got a background in psychology or neurology or sociology, or the list goes on, but very specific to the experience of being incarcerated, the challenges of reentering, the challenges of rehabilitation, the challenges of neurodivergence and disability and complex trauma and mental health and substance abuse, and the list goes on. What do you say in response to that?
The first thing I say is thank you. Thank you for your advocacy. I think it's super important that you guys are all here today and that your voices be heard on this question. And I don't take it personally at all. I don't think I really know anyone here, and I've never run across anybody here in the course of my career, but really thank you for your advocacy. It really matters. So thank you for that. I will be the first to tell you that in my CV and my resume, you do not see a doctorate degree in psychology. I do not have a degree in social work. That is absolutely true. I do have a long history of working with folks with substance use. I do have a long history of working with folks with mental health challenges. While I don't have
working with, contextualize that.
Sure. Representing them as a defense attorney, trying to find solutions when I was an assistant district attorney that would help to ameliorate and address the root causes of what brought them into court, which was almost always, particularly at the district court level, almost always substance use, mental health, or some combination of the two. Which then also leads to housing insecurity, which leads to difficulties finding employment, and those factors just cascade upon one another. And while I admit I do not have a PhD in psychology, I can tell you who does, which is my wife. And when Dr. Solhan comes home from her work as a clinical director of a veterans clinic every single day, these are coffee table and dinner table discussions for us. We watch Jeopardy, we watch Wheel of Fortune, we do those things as well. But you know, how she deals with her clients, she's one of the leading experts in CBT in this country. And I learn from her every single day. So while I admit, if you sit me down in someone's therapy session, I'd be committing malpractice, and I think probably a state and federal crime. But I do have some basis of knowledge in that work.
I can appreciate that you've been informed through your wife's experience, but my husband's a software engineer, and that's our coffee table, dinner table conversation. I guarantee you I'm not going to be able to sit down and code a damn thing. So
yeah, and I grew up with a welder as my dad. I can tell you that I can't put two pieces of metal together.
And I also guarantee he's listening to this and probably laughing right now at the very thought. No, I appreciate that. I have to share, a lot of what we heard in opposition is exactly my own reaction to your nomination. I have, you know, the Parole Board has 7 members. It's finite. There's 1 vacancy. For me, it's a binary of, you know, what would I like to see on the Parole Board and in what way do you match it? You are incapable of matching my number 1 is that I very much feel the Parole Board is lacking in someone from Western Mass on the board, and there's
You can move.
I love the Mohawk.
I promised me they were gonna move and not happen. But no, but there's both logistical reasons that I think that's important in terms of the amount of hours traveled by our current members to travel from the eastern part of the state to the Berkshire County House of Correction and every other House of Correction and DOC facility across the state, and they're on the road a ton. But also there's very unique impacts of the unique communities in Western Mass and the justice system that perspective would be very beneficial to have to help be representative on the Parole Board. Putting aside regional equity, which I do value strongly, I very much think the board would benefit from having someone with lived experience, someone else with psychological background. Some of the other suggestions made here today do land with me. So, you know, I'll end that with a question, but, you know, and really just a very broad question of give you an opportunity to respond.
I think my earlier answer, I don't want to repeat myself too much out of respect for everyone's time, but I would sort of repeat what I said earlier, which is that, you know, I do have a tremendous amount of experience working inside those spaces. And I don't mean to compare the two when I say the following, but I also do have a sense and understanding of what institutionalization feels like. When I returned after my basic training with the United States Army and I came home, I remember that morning, the next morning, walking my dog and I was alone. And I was alone and I hadn't shaved yet. And the sense of utter fear I felt walking down the street, because A, I'm alone. I'm not with my battle buddy, right? Which is never allowed in the Army. You can't be alone. It's a suicide prevention tool. And number two, I hadn't shaved yet. And even if PT's at 4:30 in the morning, you shave before PT. And the sense that I was going to turn the corner and someone was going to see me like that and be all over me for it, that's institutionalization. Is it remotely like what someone who experiences, 20 years in our state correctional facilities is like? Absolutely not. And I don't mean to suggest that at all. But I do have an understanding of what institutionalization does feel like, even if it's on a vastly smaller order of magnitude.
You done? So,
Good afternoon, Mr. DeMore. Congratulations on your nomination. Most of the questions that I would be asking, my councilmen and women already asked, but I'll ask again. What makes you different from the current parole board members that are on the parole right now?
Yeah, I think the parole board has, at the moment, you've got folks with psychology, social work backgrounds in those two slots. You have folks with parole experience in the form of the chairman. You have folks with probation experience, all of which I think are super important. Attorney Kellecourse has some experience in our criminal courts, but as I understand it, I don't think he has an extensive experience in our trial courts and in our appeals courts. So I think that sort of right off the bat, my experience in the criminal courts is a different sort of experience that I can bring to bear. I don't believe anyone has ever worked in a prosecutor's office before. So I would be, I believe, the only person who has any experience inside of a prosecutor's office. I may be mistaken. Attorney Kellecourse may have at some point early in his career, but I don't believe so. I think that I bring those experiences. I don't believe there's anyone who has any service in the United States military. And I will tell you that my generational cohort, those of us who are 20 years old on 9/11, who are, have experienced a lot, and we're also in the thick of the opioid crisis and the financial crash and everything else, that is a unique need as well in terms of how the veterans community interacts with the criminal justice system. So I think those would be some of the areas where I have a unique perspective.
Thank you. And can you talk a little bit about the work that you did with the U.S. Army when it came to victims?
Yeah. So I represent, my current assignment is I'm a special victims counsel. It's this really interesting hybrid role that the Department of Defense through Congress has, where it's like what we have traditionally with a victim witness advocate in our courthouses now, except they're an attorney and they also have standing to appear in court. So you can imagine it might be a nightmare, Counselor Kennedy, to have all of a sudden from the gallery some third lawyer stand up and object to a question. So I work with those folks. And what's important to remember with that is that's not like a VWA is in a prosecutor's office whose job it is to sort of, work with the victim and interface between them and the prosecutor's office. You represent them for all purposes in the sense that if they come to me, as sometimes they do, and they say, I don't want anything to do with this, right? This guy is my boyfriend, is my wife, whatever. And I love this person. I don't want anything bad to happen to them. I don't want there to be any negative repercussions for them. I want you to kill the case. Then that's what you do, right? Because they're the client and they drive the bus on those things. So while certainly there are many folks who are victims of military sexual trauma, domestic abuse, or child abuse who do want to see the case prosecuted, there are also many who do not. And your job is to work with them, help them understand what their options are, help them understand how the system works, because it's a very Byzantine system, and make sure that they know that they're supported with regardless what their decisions are.
You say that you're victim driven?
I would say that I certainly have a lot of experience working with people who have been victimized, obviously. But at the end of the day, victims and survivors, they are not deciders on the parole board. They get input, they have a right to be heard, where they have a right to be heard statutorily. But at the end of the day, we do not cede, we should not cede, I will not cede any control in my decision-making to what they have to say in terms of what their desired outcome is.
I know we talked about, there's individuals that have been incarcerated for criminal charges that they have not done. Do you think there's a way to manage a way of allowing the person who is incarcerated an opportunity to be heard, even if victims are coming out and saying, oh, this person is the perpetrator. However, it's not really the case. Do you think there's, something that can be done about that while you're on the parole board?
Yeah, in no way should a person who is affirming that they are actually innocent of the case, they be locked out of parole. In no way that should ever happen. And they should not be required to make some sort of admission of guilt, frankly, in some occasions, because we know it's greater than 0% to put themselves before the board. That should absolutely not be the case. They should have every opportunity to demonstrate that they are in a position to succeed if they are given the opportunity to parole. And that's what that hearing should be focused on. That's where the focus should be, not the trial court is the place to relitigate cases, not the parole board.
What does rehabilitation mean to you?
Well, it means identifying and it means identifying what are the root causes of the behavior, right? So it may be substance use, it may be mental health issues, it may be that there was some housing insecurity, it may be family issues, it may be a whole host of different things. It's identifying what those things are, taking affirmative, proactive steps to be able to address those things and to try to advance the ball on ameliorating those factors and mitigating those factors. And then putting yourself in a position where upon parole, you'll be able to continue that success, right? I think that it's about finding ways to make sure that folks never come back ever again. When I was, a prosecutor, frankly, as a defense attorney, I tell my clients, I never want to see you again, right? That when the case is over, the idea is sayonara, no more. Don't lose my number if you need me, and send me a Christmas card if you like, but I don't want to see you back in court again. That's the goal. It was the goal when I was a prosecutor. It's the goal now as defense attorney.
Do you consider yourself as law enforcement?
No, I've no point did I attend a police academy. At no point did I take any law enforcement training. I worked for a district attorney's office. That is true. I did that until the early months, February, I think, maybe January of 2019. I'm pretty sure if I get pulled over right now, I get a ticket like anybody else. No one gives me a badge that I get to get out of things on. I do not view myself as a law enforcement person at all. I'm a lawyer.
How long do you see yourself on the parole board?
Until I'm not able to make the kind of impact that I want to make, right? As I've indicated, when you look at my resume, when you look at my work and employment history, I find the ways that I can sort of maximally impact. And when I am not able to do that anymore, then that's when it's time to do something different. So why now, right? In terms of, I could do another 15 years as in my private practice. There's nothing wrong with my private practice. I enjoy my work. I enjoy my clients. But I feel like there's more I can do, that there is a broader aperture that I could be looking through. So long as this is the right spot for me, and this is the place where I can do the most good, where I can help people the most, that's what I want to continue to do.
I've heard a lot of people here with opposition, which I completely understand where they're coming from and their concerns, just like many of us here. Have you experienced any trauma, personal trauma? It could be a relative or a loved one that would make you understand that the importance of having the right person on the parole board to advocate on behalf of those who are seeking to be released, and making sure that not only that they're following protocols, getting into programs, mental health, attending treatment, substance abuse treatment program, but making sure that those that should not be incarcerated are being able to be fairly given an opportunity to be released. Have you experienced anything that makes you understand that if you should have the opportunity to be on the parole board, that you get it, you get what people are going through, and you understand why there is a need to have someone who is qualified, but also understand the need of the population, if that makes sense.
Yes, and thank you for that question. I've got a big family, and I've had family members, close family members who have struggled with substance use issues, continue to struggle with substance use issues, with mental health issues. I've buried friends decades before that should have happened. So the short answer to your question is yes, that I understand what that's like. I think others understand it better than me. That's undoubtedly so. But I have not been so fortunate to live a life absent any tragedy.
No further question.
Thank you, Councilor Dolan.
Thank you. We have heard a lot from a lot of witnesses. I thank all of them, those who testified in support of your nomination, those who testified in opposition to the nomination. As a defense attorney, I want to give you an opportunity to answer to some of, I think, the very important issues that were raised. Will you commit to serving for 5 years if you're confirmed?
Yeah, as I indicated, I will serve on the board for as long as it's the right place for me in terms of where I can provide a positive impact. If that's 5 years, 10 years, 15 years, so long as it's the place where I can provide the most good. Obviously, you know, within the context of what's going on with my family at home, then yes, I mean, so long as I'm in a position where I can do good, where I am providing value to the board, then it would be my intent to serve.
So you would commit to serving a minimum?
I can't say what the minimum would be, but for as long as I'm in a position where I'm providing value, that's what I would want to do.
When we talked about the parole rate, and I told you that my general view is that there are a lot of people who should be paroled, who aren't being paroled, people who do not pose a danger, people who could be contributing to our community. And that's really one of my top priorities. It is a significant drop to go from a 65.8% rate to a 57% rate. And what would you do as a member of the parole board to address that? Or what's your view? Do you agree with me that there are a lot of people who should be released who haven't been released?
Well, I think every case has to get decided on its individual facts, the individual merits of any given case, obviously. I don't think we should be chasing some platonic ideal of what a correct number is. I don't know why 65% would be better than 55 and be better than 70, better than 75%. That decision, that statistic is the aggregate of all of these cumulative individual decisions. What I can say is that my approach to those cases would be consistent and fair, and would, I think, be informed by the fact that I'm very mindful that second chances work, that second chances are important. And, you know, an area where that was really illustrated for me, and I think for a lot of us, was in 2012, when the drug lab was shut down initially. And all of a sudden we had statewide, I think somewhere in the neighborhood of 1,000, maybe 1,200 people who were granted stays of execution or had their bails reduced down to personal. And I think we may have discussed this even, I know I talked to somebody in the last couple of days about this, that what was remarkable about it, and maybe remarkable is not the right word, but what was great about it is that when all of a sudden virtually every drug defendant in the state who was incarcerated was suddenly not incarcerated, I'll tell you what we didn't see. We didn't see a huge spike in crime. We didn't see a massive increase in overdoses. We didn't see any of those things. And you know, what does that demonstrate? It demonstrates that that we don't have to be afraid to do the right thing when the conditions are there.
What do you say to the people who point out that if you are confirmed, then 60% of the parole board will be law enforcement? Do you see any problems with that? Is that
I'm not sure I agree with the the premise of that assessment. I think I don't view folks who work in probation as being law enforcement, certainly. Again, as I indicated, I don't view myself as law enforcement. I'm pretty certain that my clients right now don't view me that way. And the police officers I've questioned on cross-examination at times probably don't view me that way. Yeah, so I'm not sure I agree with the premise in the first instance. And people are not their backgrounds. You know, I almost got picked for a jury last Thursday on an OUI case, and the lawyer used a peremptory on me, and I don't know. I've seen exactly how screwed up our OUI prosecutions can be. Maybe that wasn't, you know, reading the book by its cover. Maybe it wasn't the right call for that lawyer.
So I was approached by someone in the store yesterday who said, you know, that parole board nominee doesn't have enough experience working with the indigent. I have to say, having been a public defender for 20 years, working with a lot of indigent people, I think it is incredibly valuable experience. So many people who are incarcerated, so many people who come before the parole board will have spent their lives being indigent. The indigent live in a different world. It is a world that is often misunderstood. So can you just share your insights, your understanding, your experience in working with the indigent?
It is not, in fairness, to be frank, it is not a focus of my practice. But I do presently represent indigent clients. I have represented indigent clients in the trial court, and my time doing that sort of ended with COVID, frankly, just for personal, you know, household decisions we made about what was safe for us and our household. But it's a very different experience, obviously, than private clients. Private clients have chosen you. There's already that baseline level of trust. You have to earn that with an indigent client. I had a client in the trial court, and he was there for his arraignment. And I handed him the police report. I said, I'm going to come back and we'll talk about it later. He says, yeah, sorry, I can't read. And I said, okay, well, I'll read it to you. And I read it to him. And then flash forward 6 months, I got him an excellent disposition on the case. And I said, okay, let's go over the green sheet. And he goes, no, it's okay. He goes, just give it to me. I'll read it. I said, what do you mean you're going to read it? And he tells me, he's like, oh, I can read. And I said, you told me you couldn't read. And he says, well, I didn't know you then. Right. And I think that was really, you know, a really interesting moment for me in terms of really fully grasping that those relationships can be so difficult to build. And there's just this baseline level of mistrust sometimes that you have to overcome. And why? Because perhaps they haven't been treated well by lawyers in the past. Perhaps folks haven't visited them. I had another client who was housed pre-trial at in Billerica. And, you know, he remarked at how incredible it was that I came and visited him as often as I did. And even when the case was over, right? The case is complete, case is done. CPCS isn't paying you anymore to go do anything. And I went and I go visit the guy to make sure that he knew exactly what the road ahead looked like, and, you know, and what he needed to do to be successful moving forward. And, you know, I mean, it was a tremendous experience. I think it's incredibly rewarding, working with indigent clients, and yeah.
I have been to the Billerica House of Corrections many times. It's a very, you know, I think probably our finest. Very different from what I've seen in other prisons. So I do want to ask you about your understanding of the realities of incarceration. I have to say, I've seen things in my practice, visiting clients. I had clients tell me about things that happened to them while they were in state prison facilities that were frankly sickening to me. I don't think that people understand just how bad it can be. Dangerous, hostile, profoundly unfair, profoundly racist. What is your understanding of the realities of incarceration?
That it's more difficult than it needs to be. That we don't need to treat folks the way that we do treat folks in a lot of these facilities. And I'm sure, you know, there are undoubtedly a lot of people who work in these places whose hearts are in the right place and want to see the right things happen. But it is a naturally cruel environment at its core.
Sorry, it's a what?
Cruel, a naturally cruel.
Naturally cruel? What do you mean by naturally?
Meaning that the very nature of it, right? That you are alienating folks from the outside world.
It's designed to be cruel.
Yeah, that it inherent in its function is an element of cruelty. And I think that And I don't think you can ever really fully appreciate it at all, at least until you've been to some of these places. And even then, you're getting a very small taste of it.
Everybody has a right to a lawyer, and the issue was raised that, you know, you've represented people, officers accused of police misconduct. They have a right to a lawyer. You have a right to have those clients, but I'm just wondering what percentage of your defense work is that?
I have never represented a client criminally who was a police officer charged with anything beyond an arraignment. And I have
That's why I asked.
represented, perhaps, I have two who I've represented in civil cases.
Okay.
And then some administrative cases, obviously, the 30A appeals, things like that.
I want to ask you about whether you have work advocating for disability justice and your thoughts on disability rights.
Not extensively, I mean, is the short answer. It's inherent in a lot of what we do, right? As defense attorneys, right? Because it's important that folks are treated fairly, and especially when it comes to those sorts of challenges, you know, to hold it against folks and make it difficult to proceed forward through the system by virtue of disabilities like that, you know, that's fundamentally unfair, right? You can't hold it against them because of those things. And I think it's something we can undoubtedly do a better job with.
Do you see substance use disorder as a disability?
I do.
The last thing is, actually, the second to last thing, the drug lab cases. My view is that the global dismissals of those cases were one of the finest moments in the history of our criminal justice system. That was a courageous decision by the SJC. It was constitutional. It was brave. So I'm frankly troubled to think that folks, and let's be frank about who those defendants were. Those were largely indigent folks with a substance use disorder. I'm frankly troubled they were not provided adequate information.
The initial notices that were sent out by the various DA's offices were being sent out by DA's offices. We were statutorily barred from offering any sort of legal counsel or advice. It would have been not only illegal, it would have been unethical for us to indicate any sort of legal.
What was the purpose of the letters?
Was to make them aware that they had the case, and then we provided phone numbers for CPCS, as I recall, the hotline that they had that they could call. It's been some time since I've looked at the notice, but that's my recollection of it.
Okay.
The subsequent notices that were sent out, which were drafted collaboratively between myself, Matt Siegel, the ACLU, and Nancy Kaplan from CPCS, those had far more information because they were coming from the committee, and they were ultimately coming from a defense attorney who has that ability to offer that legal advice.
Okay. So my last question is about pardons. And as we discussed, and as you know, the purpose of a pardon is to relieve someone of the burden of their conviction. There are folks who are contributing to our communities who have a lot to offer, but they have a conviction which may place them at risk of deportation. And it would seem to me that that category of folks would be perfect for pardon, to relieve them of the burden of their conviction. What would you do as a member of the Parole Board and the Advisory Board of Pardons to increase the number of pardons for folks like that?
I think that there can be much better communication about the availability of pardons as a real remedy. I have successfully represented individuals who have sought pardons. I've done it in the past. I have one pending right now. It's an area where I think a lot of practitioners, frankly, they don't just think of it because and when they think of it, sort of, they imagine it like federal pardons. They don't ever think of the state level pardons. And they view them more as sort of political as opposed to what I think they are here in this state, in this Commonwealth, which is that they are real, honest attempts to ameliorate past injustices, or, and in particular, disproportionate impacts on sentences, on convictions. If you get a conviction, let's say you get a conviction for digging shellfish in the Pines River without a license, that's a felony. Right. And on that felony conviction, there's a whole host of things you can't do by virtue of that. The fact that you you dug some clams in 1992 in the Pines River. The idea that would prohibit you from being able to seek a license for a firearm, or to vote in some jurisdictions, or bar you from certain federal programs, or prevent you from getting a security clearance, is an absurdity to me. The harm that we sought to remedy back in 1992, when you dug up that shellfish, which probably would have made you sick because of General Electric and the plant there, the harm that we sought to remedy has long been remedied. There's no need for someone to carry what amounts to a scarlet letter for the rest of their lives because of that decision.
Further questions?
Thank you, Councilor Ziegler.
Thank you.
Been waiting for you.
Congratulations on your nomination. Thank you for taking the time to speak with you.
Good morning again. Yeah. It's afternoon now.
Afternoon, actually. So I have a few questions for you. So when we spoke about, your vision for and what changes you would make if you were confirmed. You mentioned that you would like to see individuals coming before the board more humanized and discontinuing the use of shackles and manacles. And in our conversation, I asked you how you perceive advocating for something like that. Can you speak to that?
Sure. I think having petitioners or clients come before the board, shackles and manacles, it's not right. First, it injects and amplifies a root cause of bias, right? If I'm watching someone who's sitting there in shackles and manacles, what does that communicate? It communicates that they're dangerous right off the rip. So right away, it doesn't make any sense from that level. I think as a practical matter, I'm not sure that it makes any sense. I have been in a whole bunch of courtrooms over the course of my career where there's a person, a client sitting at the table who is not in shackles, not in manacles, is facing very serious charges, perhaps has a very serious court-involved history. And the court officer is reading the Boston Herald over there. It's not like he's, putting close eye on what's happening. Obviously, it would be a collaborative discussion with the other members of the board in terms of what their perspectives are, in terms of what are the physical plant limitations. But we can overcome physical plant limitations. Those are things that absolutely figure out and get past. But from my perspective, the idea that a person would have a difficult time reaching out to pass a note to their attorney at a hearing is unacceptable.
Another change that you indicated was perhaps discontinuing the use of polygraphs. So you questioned the efficacy of them. Can you speak to that?
Sure. They're junk science. Every court that's ever touched them has indicated the same. I candidly was unaware that there was any element here in Massachusetts that utilized polygraphs. I've only experienced them once before in my entire 20 years of practice, and that was up in New Hampshire. Outside of the context of background investigations for security clearances and the like. I see no real value to them in terms of having a probative value as to whatever questions are put to the person who's answering them. And in fact, I see a harm. I see them as being an implement and a tool of intimidation. Polygraphs are scary. The one client I had who had to take one, or didn't have to take one, he chose to take one. And I won't share what my advice was on that question, but that was his choice. Those were the longest 5 minutes of my life. I knew that man had done nothing wrong. I can only imagine what someone must feel like seeing this machine and being hooked up to all these electrodes and everything else. I mean, that's treating someone like a science experiment. I can only imagine the level of intimidation somebody might feel being required to do such a thing.
Earlier, when one of my colleagues posed a question as to whether you've attended or seen a lifer hearing, and if you have not, can you speak to why you haven't?
It's simply not a part of my practice right now. I do not represent clients who come before the board in my current practice, and I just simply have not gone for that reason.
So in our conversation earlier, I'd asked you if you perceived any controversy around your nomination, if there's anything, and this is a question I often ask candidates, if there's anything that they regret or lessons that have been learned. you spoke to, the Dukins cases as something that you're proud of. Can you speak a little bit more to that?
Yeah, I am proud of the work that we did on those cases. That was a very difficult, very challenging set of circumstances, unique, hopefully. Actually, it didn't turn out to be that unique when we found Sonia Farag shortly thereafter. But a challenging set of circumstances. When that was all over, Justice Botsford, who was our single justice, singled me out by name for the work that I did on those cases. If you flash forward a couple of years later, when I was working on the breathalyzer cases, I think that the outcomes we had there, which were very much so informed by the court's approach in the Dugan and the Farag cases, I think were fair and principled outcomes that everyone, frankly, I think was fairly pleased with. And when it turned out that the Office of Alcohol Testing had additional issues, at this point I was in private practice, both the defense community and the government worked to make sure that I was the person who was appointed as a special master to help clean that up. When you've got both sides of the equation saying that this is the fair dealer, this is the person who we think will approach it fairly and impartially, I took a lot of pride in that.
Earlier in some testimony, there was a bit of challenge as to some areas in which administrating those cases could have been done better. Can you speak to that?
Yeah, I mean, I think one thing, and I think I may have mentioned this to you, I certainly mentioned to somebody in the last couple of days, when we did those initial release determinations, in many of the other counties asked for no disrespect to my colleagues in the other counties at the time, but they asked for disproportionately high bails, I thought, given the nature of the circumstances. We did not in Suffolk County, but we did ask for GPS, and I think we overused GPS by quite a bit. Back then, I think GPS continues to be overused, frankly, in our courts, it's almost like a security blanket, I think, for folks, as if the idea that if I know where you are, I know what you're doing, which is represents surveillance for the sake of surveillance, which, as an American, I'm not particularly in favor of, and also is simply factually not true. So, I think we could have done a better job with that. I'm proud of the relationships I built through the course of that litigation. I walked out of that case with in my opinion, a real friend in the legal director of the ACLU. And I think I handled those cases ethically. I handled them consonant with the law as my clients saw them at the time. And knowing what I know now about where the SJC ultimately landed, of course, I would do things differently. But I'm proud of the way we handled the cases.
So this next question was sort of asked earlier, but I'll approach it from a different lens. It's been mentioned in this hearing that we've had other candidates come before us and not serve out their term, right? Do 2 years, 3 years, and then elevate to a judgeship or another position within the legal profession. So there's concern in the room that may be the case here. Could you speak to that? Would you commit to at least doing a term? And I preface this by, this was something that we had talked about earlier in terms of, I had asked you earlier this morning, do you see this role as something that you would do for the rest of your career? You noted that, you are still on the younger side. And you can't commit to what would be 20 years or so, which is, that's realistic. And I appreciate that response. But in terms of at least the first 5-year term.
Yeah, as I said earlier, the entire history of my public service has always been trying to find the area where I can be the most impactful. If that is at the board 4 or 5, if I'm lucky enough to get another term after that, 10 years hence, then so be it. If it's another avenue, if it's another location, then that's where I would expect myself to be, because I wouldn't want to waste those opportunities. I only get so many years on this earth to help my community, and I want to leverage what I have in the way that is most impactful.
So in terms of your experience, one of the things that has been challenged today was your experience with, whether you have adequate experience around neuroscience, around sociology, psychology, around trauma-informed practices. You speak to, having relationships with individuals, your significant other in the field. Can you talk to any training or certification or professional experience that you have that would qualify to be able to oversee decisions that are deeply rooted in mental health disparities?
And so in addition to my practical sort of what I characterize as field experience, right? Actually, working in these communities, working with these community resource platforms. I do have some formal training. I've received training in empathic communication. I've received training in trauma-informed decision-making and trauma-informed communication. So I've received those. I wouldn't call them certifications, certainly. I think that would be a stretch, and I don't want to mischaracterize them. But I do have formal training in those areas. I've got training in unconscious bias. That's something that I've first received training on that. Goodness, that had to be 2011, 2010, maybe 12, thereabouts. It was the very first time I was exposed to that. And then that's been periodically something I've revisited and had additional trainings on.
Can you speak to an instance in which you've applied this training in the field?
Well, certainly anytime I speak with either a client, whether it's on the criminal defense side or as a special victims counsel, the way you approach that conversation is informed by all of those things. Because you go into those conversations, you want to do a couple of things. You want to make sure the person understands what you're saying. You want to make sure that the person feels heard and respected themselves. They have an opportunity to tell a story that's their story in their way. And I think lawyers can be terrible at this sometimes, where they say, okay, tell me what happened, right? And then people are telling you their story, and then you interrupt them and you start asking all your follow-up questions right away. And so, anytime I meet with a client for the first time, just by way of example, they tell their story their way first. And then only when they've had their opportunity to tell their story exactly as they wish to tell it, only then do we go back and we start working through some of the details and being mindful that, asking questions about some of those details can itself be triggering, can itself be difficult, and always approaching those conversations with that in mind.
The last question I'll pose to you is, this board is one that is highly viewed as the Commonwealth. It's one that holds immense power to truly impact lives, right? To set the course for someone's next steps. So understandably, there's a lot of concern about making sure that there's the right leadership on the board, right sets of qualifications, skills, that the board can be trusted in terms of decision making. There's conversation earlier around the breadth and the depth of the caseload that the board has. And so we're sitting here before us to decide whether or not, the qualifications that you bring to the table will help to elevate so that it's efficient. What unique perspective do you feel that you would bring to the table to instill
I can answer that question.
Don't want to instill trust and not fear within the efficacy and the efficiency of the program.
And I think that speaks to the legitimacy of the institution, right? Because it's important that clients believe that they're given a fair shake, that they're being heard and have an opportunity to be heard. It's important that community at large believes that the parole board is handling things appropriately, because all of that speaks to legitimacy. And I think that's very, very important. I think that the board in me will get someone who's an incredibly hard worker. I have never gone away from hard work in my entire life. I have gainfully employed since the age of 13 when Dad let me start putting a broom in the machine shop. And he threatened to fire me a week later because I wasn't working hard enough, and I never had that problem again. So I work hard. I listen. I have a lot to learn. I will be the first to tell you that. I have experiences. I have a set of professional and personal experiences that I think I bring to the table that are different than those that the board presently has. You know, as we indicated earlier, someone who's worked in the criminal justice system on the criminal courts, as someone who's, you know, represented folks in the defense context, as someone who understands the unique culture that veterans and service members have, who are a portion of our incarcerated population. You know, I bring those things to the table, and I told all the board members when I spoke to them, I'll be a good coworker. You know, I work hard. I will be there to pick people up, and I'll want to make it a better place every day.
Council Ziegler, believe it or not, you've gone way past the 15 minutes under our rule. And we do have an assembly we have to do.
That was my last question. That was my last question.
Your last question, great. That. I'm only gonna take a couple of minutes because we do have other work to do. The concerns that everybody raised here are certainly legitimate. No question about it. And I see it as two things. One is, are we putting a prosecutor on the bench? You know, I've known you for a long time. I've had cases with you when you were a prosecutor over the years. And, you know, I've seen you in the courts as a defense lawyer. You know, when we talk about people being law enforcement, you're not law enforcement forever. I don't think anybody in the Commonwealth of Massachusetts legal system thinks of me as a prosecutor. I was a prosecutor a very, very long time ago. We grow, we move on, people who are prosecutors that later become defense lawyers, in my opinion, become much better lawyers because they get both perspectives. And I just want to point that out. I don't look at you as a prosecutor, and I haven't for a very long time. That's number one. Number two, that was direct question number one, and I think Councilor Civil asked you about that as well as Councilor Dolan, so I'm not going to belabor that. But the more important question that for them is, I think there's a lot of concern that Jean Trustoy raised, as well as Patty Gowan, is how long are you going to sit? And they keep bringing that up. As we sit here today, very simple question. I'm going to ask for a yes or no. As we sit here, is your intention to complete the full first 5 years? I know you said it'd be 5 or 10 or 15. As we sit here today, is it your intention to complete the first 5 years?
As I sit here today, yes, that's the work that's in front of me. I have no plans on going anywhere else as I sit here today.
All right, thank you. With that, we'll adjourn.
I'm gonna go ahead and call our meeting to order. I'd like to recognize Counselor Kennedy for a moment of reflection or a prayer and leading us in the Pledge of Allegiance, please.
Just a moment of silence for all of those people that are in danger in the Middle East at this time, and hopefully that the ceasefire holds and we're able to come to a resolution of this terrible situation. Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, everyone. I'd like to recognize Counselor Dolan for a motion to record advice and consent for the financial warrant.
So moved.
Motion's been made. Is there a second? Seconded by Counselor Ziegler. All those in favor? Any opposed? The ayes have it. I'd like to recognize Counselor Civil for a motion to record advice and consent for the pending list of notaries public and justices of the peace.
So
And is there a second?
Second.
Seconded by Counselor Ziegler. All those in favor? Any opposed? The ayes have it. I'd like to recognize Counselor Kennedy for a motion to record advice and consent for the appointment of Michelle Lichardi to the position of Associate Justice of the Boston Municipal Court.
With great pleasure, I make that motion.
Motion's been made. Is there a second? Seconded by Counselor DiPaolo. Any further questions or comments? Seeing none, I would ask Sonia to please call the roll.
Counselor Kennedy,
Yes.
Counselor DePaulo,
Yes.
Counselor Jacobs,
Yes.
Counselor Civil,
yes.
Counselor Dolan,
Yes.
and Counselor Ziegler.
Yes.
6 members voting, 6 in the affirmative. The matter carries. I do not think we have any other business unless you have hearings you want to report out.
Move to adjourn.
Motion made by Counselor Jacobs to adjourn, seconded by Counselor Ziegler. All those in favor? Any opposed? The ayes have it. Stand